present. The Senate will come to order. Mr. Carpenter, please call the roll.
Senators Bridges, Cook, Corum, Court, Crowder, Danielson, Donovan, Finberg, Fields, Foote, Gardner, Janal, Gonzalez, Hill, Heisey, Holbert, Lee, Lundeen, Marble, Moreno, Pedersen, Priola,
Excused.
Rankin, Rodriguez, Scott, Smallwood, Sonnenberg, Story, Tate, Todd, Williams,
Excused.
Winter, Woodward, Zinzinger. Mr. President.
Here. With 33 present, 0 absent, and 2 excused, we have a quorum. Senator Pedersen, will you please lead us in the Pledge of Allegiance?
Pledge allegiance
To the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You said my name.
Approval of the Journal. Approval of the Journal. Senator Lundeen. Senator Lundeen.
Thank you very much, Mr. President. I move that the reading of the Journal for Friday, March 22nd, 2019 be read at length and then entered into the record as corrected by the Secretary.
You have heard the motion. Is there any discussion? Senator Smallwood.
Thank you, Mr. President. Good morning. Good morning, colleagues. Mr. President, I'm going to move corrections to the Journal of Friday, March 22nd, 2019. Looking for you to let me know if that's something that I can do now or after the Journal is read, sir.
Mr. Carpenter, please read the Journal at length, and then we will consider amendments to the Journal.
Senate Journal, 78th day, March 22nd, 2019, page 529. Senate Journal, 72nd General Assembly, State of Colorado, first regular session. 78th Legislative Day, Friday, March 22nd, 2019. Prayer by the Chaplain Jonathan Drinkwine, Area Director of Young Life, Douglas County, called to order by the President at 9 a.m. Roll call. Present 34, excuse 1 Bridges. Present later, 1 Bridges. Quorum. The President announced a quorum present pledged by Senator Lee. Reading of the Journal. Senator Heisey moved the reading of the Journal, Thursday, March 21st, 2019, be dispensed with, and the Journal be approved as corrected by the Secretary. On a substitute motion pursuant to Senate Rule 14B, and at the request of Senator Hill, the Journal of Thursday, March 21st, 2019, was read at length and approved as corrected by the Secretary. Committee of Reference Reports, Appropriations after consideration of the merits. Committee recommends that Senate Bill 203 be referred to Committee of the Whole. The favorable recommendation. Appropriations after consideration of the merits. Committee recommends that Senate Bill 133 be amended as follows: as amended, be referred to Committee of the Whole. The favorable recommendation. Amend the Senate Health and Human Services Committee report dated February 21st, 2019, page 11. After line 15, insert section 10, Appropriation 1 for the 2019-20 state fiscal year, $33,622 is appropriated to the Department of Regulatory Agencies. This appropriation is from the Division of Professions and Occupations Cash Fund created in Section 24341052B1 CRS To implement this act, the department may use this appropriation as follows. A, $13,374 for use by the Division of Professions and Occupations for personal services, which amount is based on an assumption that the division will require an additional .2 FTE. B, $4,703 for use by the Division of Professions and Occupations for operating expenses. And C, $15,545 for use by the Executive Director's Office and Administrative Services for the purchases of legal services. 2, for the 2019-20 state fiscal year, $15,545 is appropriated to the Department of Law. This appropriation is from reappropriated funds received from the Department of Regulatory Agencies under subsection 1C. This section is based on the assumption that the Department of Law will require an additional .1 FTE. To implement this act, the Department of Law may use this appropriation to provide legal services for the Department of Regulatory Agencies. Page 530, Senate Journal, 78th day, March 22nd, 2019. Read number 16 sections accordingly. Amend printed bill, page 1, line 101, strike counselors and substitute counselors and in connection with making an appropriation. Appropriations, after consideration of the Mayor's Committee recommends that Senate Bill 137 be amended as follows. As amended, be referred to committee to hold. The favorable recommendation placed on the consent calendar. Amend printed bill, page 3, after line 7, insert section 4, appropriation for the 2019-20 state fiscal year. $218,825 is appropriated to the Department of Higher Education. This appropriation from the general fund is based on the assumption that the department will require an additional 1 FTE to implement this act. The department may use the appropriation for the Colorado Student Leaders Institute. Read number 16 section accordingly. Page 1, line 102, strike institute and substitute institute and in connection therewith making an appropriation. Appropriations after consideration of the Mayor's Committee recommends that Senate Bill 154 be referred to committee to hold. The favorable recommendation. Appropriations after consideration of the Mayor's Committee recommends that Senate Bill 162 be referred to committee to hold. The favorable recommendation placed on the consent calendar. Appropriations after consideration of the Mayor's Committee recommends that Senate Bill 164 be referred to committee to hold. The favorable recommendation placed on the consent calendar. Appropriations after consideration of the Mayor's Committee recommends that Senate Bill 52 be referred to the committee to hold. The favorable recommendation placed on the consent calendar. Education, the Committee on Education has had in consideration a head hearing on the following appointments. Recommends appointments to be placed on the consent calendar. Confirmed members of the Board of Trustees for the Colorado School for the Deaf and the Blind for a term expiring July 1st, 2020. And McElhaney of Colorado Springs, Colorado, Republican, reappointed for terms expiring July 1st, 2022. Nancy Inez Brown of Colorado Springs, Colorado, Republican, reappointed. Michelle Ann Butler of Colorado Springs, Colorado, and unaffiliated, reappointed. Alan G. Ward of Poncha Springs, Colorado, an unregistered voter, appointed. Senate Journal, 78th day, March 22nd, 2019, page 531. Education. The Committee on Education has had a consideration and head hearing on the following appointment and recommend the appointment be placed on the consent calendar and confirmed. Member of the Colorado Student Leaders Institute Executive Board for a term expiring July 7, 2019, Brian David Yates of Buena Vista, Colorado, to serve as a person of the community who has an interest or experience in education occasioned by the resignation of Letty Garcia Eckstein, reappointed. Education. The Committee on Education has had in consideration and had a hearing on the following appointments and recommends the appointments be placed on the consent calendar confirmed. Members of the Colorado Commission on Higher Education for term expiring July 1st, 2019, Stephanie F. Donner of Denver, Colorado, resident of the 1st Congressional District, a Democrat, occasioned by the resignation of John L. Anderson of Durango, Colorado, appointed for terms expiring July 1st, 2022. Pardis Madivi, PhD of Denver, Colorado, resident of the 1st Congressional District, a Democrat, appointed. Manisha B. Kerr of Aurora, Colorado, resident of the 6th Congressional District, and Democrat, reappointed. Education. Committee on Education has had a consideration and had a hearing on the following appointments and recommends the appointments be placed on the consent calendar confirmed. Members of the Board of Trustees for Fort Lewis College for term expiring December 31st, 2022. Jane Akir Lopez, Vilsack, PhD of Mountain View, Colorado, a Democrat, appointed. Alan G. Hill, Denver, Colorado, an unaffiliated, reappointed. Education. The Committee on Education has had under consideration and has had a hearing on the following appointments and recommends the appointment be placed on the consent calendar and confirmed. Member of the College Invest Board of Directors for term expiring July 31st, 2022, Sarah R. Williamson, CFP, CIMA, CDFA of Denver, Colorado, reappointed. Education. After consideration of the Merits Committee recommends that Senate Bill 171 be referred to Committee on Appropriations with a favorable recommendation. Page 532, Senate Journal, 70th day, March 22nd, 2019. Transportation and Energy. After consideration of the Mayor's Committee recommends that Senate Bill 96 be amended as follows. As so many be referred to Committee on Appropriations with a favorable recommendation. And then page 4, line 15, strike modeled on and that mirror. Page 5, line 13, strike basis and substitute basis that aligns with the timing of required federal greenhouse gas reporting. Page 5, line 15, after law and add and. Page 5, after line 15, insert 3, report in metric tons the amount of emissions of each of the 7 individual components of greenhouse gases, as well as the carbon dioxide equivalent of those emissions. Page 6, strike lines 9 and 10, read letter 16 subparagraphs accordingly. Page 6, line 18, strike 2005, 2007, 2014, and substitute 2005. Page 6, line 19, strike inventories and substitute inventory. Page 6, line 26, strike year and substitute 5 years. Page 7, line 1, strike section and substitute section, except that the Commission can specify a different period if it determines that an earlier forecast is needed due to the occurrence of an extraordinary event that would significantly affect the forecast. Senate Services report correctly printed. Senate Bill 205 and 206 correctly engrossed. Senate Bill 2, 3, and 10 correctly revised. House Bill 1007, 1106, 1129, 1166, 1173, and 1209 correctly enrolled. Senate Bill 109, A motion of Majority Leader Finbeck, where the majority of those elected to the Senate having voted in the affirmative, the Senate proceeded out of order for a moment of personal prayer. Senate in recess. Senate reconvened on motion of Majority Leader Finbeck, and with the majority of those elected to the Senate having voted in the affirmative, the Senate proceeded out of order for consideration of general order, second reading of bills, Committee of the Whole. A motion of Senator Moreno, the Senate resolved itself from the Committee of the Whole for consideration of general orders, second reading of bills, and Senator Moreno was called to act as chair. Senate Journal, 78th day, March 22nd, 2019, page 533, General Order, second reading of bills. The Committee of the Whole, having risen, the chair reported that the following bills had been considered and action taken thereon as follows. House Bill 1177, Representatives Sullivan and Garnett, also Senators Court and Pedersen, concern creation of extremist protection order in connection therewith, making an appropriation. Amendment number 1, State Veterans and Military Affairs Committee Amendment, printed in the Senate Journal, March 18th, page 41 through 42, and placed in members' bill files. At the request of Senator Hill, the bill was read at length as amended, ordered, revised, and placed on the calendar for third reading and final passage. For further action, see amendments to the report of the Committee of the Whole. Senate Bill 5 by Senators Rodriguez and Janal, also Representatives Hawkins Lewis, concerning wholesale importation of prescription pharmaceutical products from Canada for resale to Colorado residents. Amendment number 1, Health and Human Services Committee Amendment. Printed in Senate Journal, February 1st, pages 142 through 143, and placed in members' bill files. Amendment number 2, Appropriations Committee Amendment. Printed in Senate Journal, March 19th, page 488, and placed in members' bill files. Amendment number 3, L018 by Senator Janal. Amendment printed bill, page 4, line 7, strike 384 and substitute 384, and includes only prescription pharmaceutical products that are intended for human consumption. Senator Hill requested the bill be read at length, then later asked that the reading be dispensed with. As amended, ordered, engrossed, and placed on the calendar for third reading and final passage. The chair reported that the following bills, reading at length, have been dispensed with by unanimous consent, have been considered an action taken thereon as follows. House Bill 1135 by Representatives Gray, also Senators Tate and Winter, concerning a clarification that the income tax credit for retrofitting residents to increase a residence's accessibility is available for changes made to a residence to benefit a qualified individual's dependent. Order revised, place the calendar for the reading and final passage. House Bill 1170 by Representatives Jackson and Weissman, Senators Williams and Bridges, concerning increasing tenant protections relating to the residential warranty of habitability. Amendment number 1, Local Government Committee Amendment, printed in Senate Journal, March 15, page 478 through 479, and placed in members' bill files. Amendment number 2, L024 by Senator Williams, amend re-engross bill, page 5, strike lines 22 and 23, and substitute 96 hours where the condition is as described in subsection 2A1 of this section, and the tenant has included. Page 534, Senate Journal, 70th day, March 22nd, 2019. With the notice permission to the landlord or the landlord's authorized agent to enter the residential premises, page 11, line 8, strike 2, and substitute 4, page 11, line 22, strike 2, and substitute 4. Amendment number 3, L027 by Senator Williams, amend re-engross bill, page 5, line 6, strike 2.3 and 2.5, and substitute 2.2, 2.3, and 2.5, page 5, line 7, strike A, and substitute except as described in subsection 2.2 of this section A, page 5, after line 23, insert 2.2, in a case in which a residential premises has mold that is associated with dampness, or there is any other condition causing the residential premises to be damp, which condition, if not remedied, would materially interfere with the life, health, or safety of a tenant or landlord, breaches the warranty of habitability if the landlord fails, A, within 24 hours to mitigate the immediate risk from mold by installing a containment stopping active sources of water to the mold, and installing a high efficiency particulate air filtration device to reduce tenants' exposure to mold. B, to maintain the containment described in subsection 2.2A of this section until the action described in subsection 2.2C of this section are executed. And C, within a reasonable amount of time to execute the following remedial actions: to remove the health risk posed by the mold. 1, establish appropriate protections for workers and occupants. 2, eliminate or limit moisture sources and dry all materials. 3, decontaminate or remove damaged materials as appropriate. 4, evaluate whether the premises has been successfully remediated. And 5, reassemble the premises to control sources of moisture and nutrients and thereby prevent or limit the recurrence of mold. Amendment number 4, L028 by Senator Williams, amend re-engross bill, page 4, after line 24, insert 6. Mold means microscopic organisms or fungi that can grow in damp conditions in the interior of a building. Read numbers exceeding subsections accordingly, page 5, lines 12 and 13. Strike is materially dangerous or hazardous. 2, and substitute strike is, unstrike materially, strike dangerous or hazardous. 2, unstrike interferes with, page 7, line 4. Strike tenant and substitute tenant excluding the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning and intended use. Senate Journal, 78th day, March 22nd, 2019, page 535, amendment number 5, L029 by Senator Williams. Amend re-engross bill, page 5, line 6, strike 2, and substitute 2, 3, page 6, after line 6, insert 3, when any condition described in subsection 2 of this section is caused by the misconduct of the tenant, a member of the tenant's household, a guest or invitee of the tenant, or a person under the tenant's direction or control, the condition does not constitute a breach of the warranty of habitability. It is not misconduct by a victim of domestic violence, domestic abuse, unlawful sexual behavior as described in section 1622-1029, or stalking under this subsection 3 if the condition is the result of domestic violence, domestic abuse, unlawful sexual behavior as described in section 1622-1029, or stalking and the landlord has been given written or electronic notice and evidence of domestic violence, domestic abuse, and unlawful sexual behavior as described in section 1622-1029, or stalking as described in section 3812-4022A. As amended, order revised, placed on calendar for third reading and final passage. Amendments to the report of the Committee of the Whole, House Bill 1177 by Representatives Sullivan and Garnett, also Senators Court and Pedersen, concerning creation of extreme risk protection order and in connection therewith making an appropriation. Senator Sonnenberg moved to amend the report of the Committee of the Whole to show that the following Sonnenberg floor amendment to L086 to House Bill 1177 does fit under the title and did pass. Amend Green-Gross Bill, page 3, strike lines 2 through 26 and substitute section 1 in Colorado Revised Statutes 2765-105. Amend 1A11B and 5 as follows. 2765-105, emergency procedure 1. Emergency procedure may be invoked under one of the following conditions. A1, when any person appears to have a mental health disorder and as a result of such mental health disorder appears to be an imminent danger to others or to himself or herself, or appears to be gravely disabled and the person is in need of extreme risk protection order, then an intervening professional as specified in section 1A2 of this section upon probable cause and with such assistance as may be required may take the person into custody or cause the person to be taken into custody and placed in a facility designated or approved by the executive order director for a 72-hour treatment and evaluation to be conducted by a psychologist. If such facility is not available, the person may be taken to an emergency medical services facility for evaluation by a psychologist. B, upon an affidavit sworn to or affirmed before a judge that relates sufficient facts to establish that a person appears to have a mental health disorder and as a result of the mental health disorder appears to be an imminent danger to others or to himself or herself, or appear to be gravely disabled and the person is in need of extreme risk protection order, the court may order the person described in the affidavit to be taken into custody and placed in a facility designated or approved by the executive director for a 72-hour treatment and evaluation to be conducted by a psychologist. Whenever in this Article 65 a facility is to be designated or approved by the executive director, hospitals, if available, must be approved or designated in each county before other facilities are approved or designated. Whenever in this Article 65 facility is to be designated or approved by the executive. Page 536 in the Journal, 78th day, March 22nd, 2019. Director is a facility for a stated purpose. The facility is to be designated or approved as a private facility. The consent of the private facility to the enforcement of standards set by the executive director is a prerequisite to the designation or approval. 5, each person admitted to a 72-hour treatment and evaluation facility under the provisions of this strike article shall, on strike Article 65, must receive an evaluation to be conducted by a psychologist as soon as possible after he or she is admitted, and strike shall, on strike must receive such treatment and care as his or her condition requires for the full period that he or she is held, and the psychologist shall file a copy of the evaluation with the district court where the person admitted resides. The court then shall determine whether to proceed pursuant to section 2765-107. The person strike shall, on strike must be released before 72 hours have elapsed. If, in the opinion of the professional person in charge of the evaluation, the person no longer requires evaluation or treatment, person who have been detained for 72 hours, evaluation or treatment, strike shall, on strike must be released, referred for further care and treatment in a voluntary basis, certified for treatment pursuant to section 2765-107, section 2 in Colorado Revised Statutes 2765-106, amend 6 and 7 as follows. 2765-106, court-ordered evaluation for persons with mental health disorders. 6, whenever it appears by petition and screening pursuant to this section, to this satisfaction of the court that the probable cause exists to believe that the respondent has a mental health disorder and as a result of the mental health disorder is a danger to others or to himself or herself, or is gravely disabled and the person is in need of extreme risk protection order, that efforts have been made to secure the cooperation of the respondent, strike who on strike, but he or she has refused or failed to accept evaluation voluntarily, the court shall issue an order for evaluation authorizing a certified peace officer to take the respondent into custody and place him or her in a facility designated by the executive director for the 72-hour treatment and evaluation to be conducted by a psychologist. At the time of taking the respondent into custody, by a copy of the petition, the order for evaluation must be given to the respondent promptly thereafter to any one person designated by the respondent and to the person in charge of the 72-hour treatment evaluation facility named in the order or his or her designee. 7, the respondent strike shall, on strike must be evaluated as promptly as possible, and strike shall, on strike must in no event be detained longer than 72 hours under the court order, excluding Saturdays, Sundays, and the holidays if treatment or evaluation services are not available on those days. The psychologist shall file a copy of the evaluation with the district court where the person admitted resides within 72 hours, and the court shall hold a hearing immediately after receiving the report to determine whether to proceed pursuant to Section 2765-107. Within that time, the respondent strike shall on strike must be released, referred for further care and treatment on a voluntary basis, or certified for short-term treatment. Strike pages 4 through 32, renumber succeeding sections accordingly. Less than a majority of all members elected to the Senate having voted in the affirmative, the amendment to the report of the committee of the whole was lost on the following roll call vote. Senate Journal, 78th day, March 22nd, 2019, page 537. Yes, 16. No, 19. Excuse, 0. Absent, 0. Bridges, no. Cook, yes. Quorum, yes. Court, no. Crowder, yes. Danielson, no. Donovan, no. Finberg, no. Fields, no. Foote, no. Gardner, yes. Janal, no. Gonzalez, no. Hill, yes. Heise, yes. Holbert, yes. Lee, no. Lundin, yes. Marble, yes. Moreno, no. Pedersen, no. Priola, yes. Rankin, yes. Rodriguez, no. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, no. Tate, yes. Todd, no. Williams, no. Winter, no. Woodward, yes. Zinzinger, no. President, no. Call the Senate, call raise Senator Tate. Move to amend the report of the committee of the whole to show that the following Tate floor amendment L077 and House Bill 1177 did pass. Amend the State Veterans and Military Affairs Committee report dated March 15, 2019, page 1, strike line 19. Less than a majority of all members elected to the Senate having voted in the affirmative, the amendment to the report of the committee of the whole was lost on the following roll call vote. Yes, 11, no, 19. Excuse, 0. Absent, 5. Bridges, no. Cook, yes. Quorum, absent. Courts, no. Crowder, absent. Danielson, no. Donovan, no. Finberg, no. Fields, no. Foote, no. Gardner, yes. Janal, no. Gonzalez, no. Hill, yes. Heise, yes. Holbert, yes. Lee, no. Lundin, yes. Marble, yes. Moreno, no. Pedersen, no. Priola, absent. Rankin, yes. Rodriguez, no. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, no. Tate, yes. Todd, no. Williams, no. Winter, no. Woodward, yes. Zinzinger, no. President, no. Senator Hill moved to amend the report of the committee of the whole so the following Hill floor amendment L087, House Bill 1177 did pass. Amend Greengrove's bill, page 6, line 27, strike firearm and substitute firearm except for firearm necessary to conduct any military employment related duties. Page 15, line 1, strike firearm and substitute firearm except for a firearm necessary to conduct any military employment related duties. Less than a majority of all members elected to the Senate having voted in the affirmative, the amendment to the report of the committee of the whole was lost on the following roll call vote. Page 538, Senate Journal, 78th day, March 22nd, 2019. Yes, 12. No, 18. Excuse, 0. Absent, 5. Bridges, no. Cook, yes. Quorum, absent. Court, no. Crowder, absent. Danielson, no. Donovan, no. Finberg, no. Fields, no. Foote, no. Gardner, yes. Janal, no. Gonzalez, no. Hill, yes. Heise, yes. Holbert, yes. Lee, no. Lundin, yes. Marble, yes. Moreno, no. Pedersen, no. Priola, absent. Rankin, yes. Rodriguez, no. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, no. Tate, yes. Todd, no. Williams, no. Winter, no. Woodward, yes. Zinzinger, no. President, yes. Senator Marble moved to amend the report of the committee of the whole to show the following Marble floor amendment L088 to House Bill 1177 did pass. Amend Greengrove's bill, page 15, line 21, strike 12, and substitute 12A, page 16 after line 2, insert 12B. If the court denies the issuance of an extreme risk protection order, but ordered a temporary extreme risk protection order, the court shall destroy all records related to the petition for the temporary extreme risk protection order and the petition for the extreme risk protection order and remove all associated records from online sources. Less than a majority of all members elected to the Senate having voted in the affirmative, the amendment to the report of the committee of the whole was lost on the following roll call vote. Yes, 11, no, 19. Excuse, 0. Absent, 5. Bridges, no. Cook, yes. Quorum, absent. Court, no. Crowder, absent. Danielson, no. Donovan, no. Finberg, no. Fields, no. Foote, no. Gardner, yes. Janal, no. Gonzalez, no. Hill, yes. Heise, yes. Holbert, yes. Lee, no. Lundin, yes. Marble, yes. Moreno, no. Pedersen, no. Priola, absent. Rankin, yes. Rodriguez, no. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, no. Tate, yes. Todd, no. Williams, no. Winter, no. Woodward, yes. Zinzinger, no. President, no. Adoption of the report of the committee of the whole. Motion of Senator Moreno. The report of the committee of the whole was adopted on the following roll call vote. Yes, 30. No, 0. Excuse, 0. Absent, 5. Bridges, yes. Cook, yes. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heise, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. The Committee of the Whole took the following action and passed on second reading Senate Bill 5 as amended, House Bill 1177 as amended, House Bill 1135, House Bill 1170 as amended. Senate Journal, 78th day, March 22nd, 2019, page 539, third reading of bills, final passage. On third reading, the titles of the following bills are publicly read, the reading at length having been dispensed with by unanimous consent. House Bill 1106 by Representatives Daytona, Gonzalez, Gutierrez, Benavides, Buckner, Coleman, Durango, Lindo, Harrod, Jackson, Hawkes, Lewis, Kennedy, Lontein, McLaughlin, Singer, Sirota, Valdez, A. Weissman, also Senators Pedersen, concerning the rental application process for prospective tenants. The question being, shall the bill pass? The roll call was taken with the following result. Yes, 20, no 10, excuse 0, absent 5. Bridges, yes. Cook, no. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Benberg, yes. Fields, yes. Foote, yes. Gardner, no. Janal, yes. Gonzalez, yes. Hill, no. Heisey, no. Holbert, no. Lee, yes. Lundeen, no. Marvel, no. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, no. Story, yes. Tate, no. Todd, yes. Williams, yes. Winter, yes. Woodward, no. Zenzinger, yes. President, yes. Majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added: Bridges, Danielson, Donovan, Finberg, Fields, Garcia, Janal, Gonzalez, Moreno, Rodriguez, Story, Todd, Williams, Winter, and Zenzinger. Senate Bill 2 by Senators Winter and Finberg, also Representatives Roberts and Jackson, concerning the regulation of student education loan servicers and in connection therewith making an appropriation. The question being, shall the bill pass? The roll call was taken with the following result. Yes, 21, no 9, excuse 0, absent 5. Bridges, yes. Cook, no. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, no. Janal, yes. Gonzalez, yes. Hill, no. Heisey, no. Holbert, no. Lee, yes. Lundeen, no. Marble, no. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, no. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, no. Zenzinger, yes. President, yes. A majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added: Bridges, Danielson, Donovan, Fields, Foote, Garcia, Gonzalez, Lee, Moreno, Pedersen, Rodriguez, Story, Tate, Todd, and Williams. House Bill 1007 by Representative Sirota, also Senator Zenzinger, concerning the establishment of contribution limits under the Fair Campaign Practices Act for candidates for county offices in connection with making an appropriation. The question being, shall the bill pass? The roll call was taken with the following result. Page 540, Senate Journal, 78th day, March 22nd, 2019. Yes, 19, no 11, excuse 0, absent 5. Bridges, yes. Cook, no. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, no. Janal, yes. Gonzalez, yes. Hill, no. Heisey, no. Holbert, no. Lee, yes. Lundeen, no. Marble, no. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, no. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, no. Story, yes. Tate, no. Todd, yes. Williams, yes. Winter, yes. Woodward, no. Zenzinger, yes. President, yes. A majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added: Court, Finberg, Fields, Foote, Garcia, Gonzalez, Lee, Moreno, Todd, and Winter. Senate Bill 10 by Senator Fields, also Representatives McLaughlin and Valdez D, concerning professional behavioral health services for schools and in connection therewith making an appropriation. The question being, shall the bill pass? The roll call was taken with the following result. Yes, 22, no 8, excuse 0, absent 5. Bridges, yes. Cook, no. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, no. Janal, yes. Gonzalez, yes. Hill, no. Heisey, yes. Holbert, no. Lee, yes. Lundeen, yes. Marble, no. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, no. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, no. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, no. Zenzinger, yes. President, yes. Majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added: Bridges, Court, Finberg, Garcia, Janal, Gonzalez, Lee, Moreno, Pedersen, Story, Todd, Winter, and Zenzinger. Senate Bill 3 by Senators Zenzinger and Quorum, also Representatives McLaughlin and Wilson. Rankin, concerning the Educator Loan Forgiveness Program to address educator shortages in connection therewith making an appropriation. The question being, shall the bill pass? The roll call was taken with the following result. Yes, 25, no 5, excuse 0, absent 5. Bridges, yes. Cook, yes. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, no. Janal, yes. Gonzalez, yes. Hill, no. Heisey, yes. Holbert, yes. Lee, yes. Lundin, no. Marble, no. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, no. Zenzinger, yes. President, yes. Majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added: Bridges, Cook, Court, Donovan, Finberg, Fields, Foote, Garcia, Gardner, Janal, Gonzalez, Heising, Moreno, Pedersen, Rankin, Rodriguez, Sonnenberg, Story, Todd, Williams, and Winter. Senate Journal, 78th day, March 22nd, 2019, page 541. House Bill 1129 by Representatives Michelson, Janane, Escar, Duran, Herod, Valdez, A. Galindo, Hackus, Lewis, Titone. Also Senators Finberg, Moreno, Janal, concerning prohibiting a mental health care provider from engaging in conversion therapy with a patient under 18 years of age, laid over until Monday, March 25th, retaining its place on the calendar. House Bill 1173 by Representatives Garnett and Neville, Becker. Also Senators Finberg and Holbert, concerning the authority of an ex officio member of the Legislative Council to appoint a temporary replacement for that ex officio member at a meeting of the Legislative Council. The question being, shall the bill pass? The roll call was taken with the following result: yes 30, no 0, excused 0, absent 5. Bridges, yes. Cook, yes. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. A majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added: Cook, Court, Garcia, Gonzalez, Marble, Rodriguez, Story, and Tate. House Bill 1209 by Representatives Froelich and Valdez A. Also Senators Bridges, concerning repealing aeronautical reporting requirements. The question being, shall the bill pass? The roll call was taken with the following result: yes 30, no 0, excused 0, absent 5. Bridges, yes. Cook, yes. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. Majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added: Rankin, Tate, Winter, and Woodward. House Bill 1166 by Representatives Singer and Larson, also Senator Zenzinger, concerning name-based criminal history record checks in connection with requiring certain persons and entities to submit to a name-based criminal history record check as a condition of employment, appointment, registration, licensure, certification. The question being, shall the bill pass? The roll call was taken with the following result. Page 542, Senate Journal, 78th day, March 22nd, 2019. Yes 30, no 0, excused 0, absent 5. Bridges, yes. Cook, yes. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. A majority of all members elected to the Senate having voted in the affirmative, the bill is passed. Co-sponsors added: Gonzalez, Lee, Tate, Williams, Winter, and Woodward. Committee of the Whole, motion of Senator Moreno. The Senate resolved itself in the Committee of the Whole for consideration of general orders, second reading of bills. Consent calendar, and Senator Moreno was called to act as chair. General order, second reading of bills. Consent calendar. The Committee of the Whole, having risen, the chair reported the following bills, reading of length, having been dispensed with by unanimous consent, had been considered and action taken thereon as follows. Senate Bill 144 by Senator Zenzinger, also Representative Roberts, concerning allowing a driver of a motorcycle to proceed past a malfunctioning traffic control signal. Amendment number 1, Transportation and Energy Committee Amendment. Printed in the Senate Journal, March 20th, page 499, and placed in members' bill files as amended. Order and gross placed on the calendar for third reading and final passage. Adoption of the report of the Committee of the Whole. Consent calendar. On motion of Senator Moreno, the report of the Committee of the Whole was adopted on the following roll call vote: yes 30, no 0, excused 0, absent 5. Bridges, yes. Cook, yes. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. The Committee of the Whole took the following action: passed on second reading, Senate Bill 144 as amended. Senate Journal, 78th day, March 22nd, 2019, page 543, consideration of resolutions. Senate Resolution 5 by Senator Heisey concerning recognition of Single Parents Day. On motion of Senator Heisey, the resolution was read at length and adopted by the following roll call vote. Yes 30, no 0, excuse 0, absent 5. Bridges, yes. Cook, yes. Quorum, absent. Court, yes. Crowder, absent. Danielson, yes. Donovan, yes. Vinberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, absent. Rankin, yes. Rodriguez, yes. Scott, absent. Smallwood, absent. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zinzinger, yes. President, yes. Co-sponsors added: Bridges, Cook, Court, Danielson, Donovan, Finberg, Fields, Foote, Garcia, Gardner, Janal, Gonzalez, Hill, Holbert, Lee, Lundin, Marble, Moreno, Pedersen, Rankin, Rodriguez, Sonnenberg, Story, Tate, Todd, Williams, Winter, Woodward, and Zinzinger. Message from the House, March 22nd, 2019. Mr. President, the House has passed on third reading and transmitted the Riser Statutes, House Bill 1174, 1225, 1208, 1087, amendments printed in the House Journal, March 21st, 2019. The House has passed on third reading and returns herewith Senate Bill 152, 151. The House has passed on third reading and transmitted the Riser Statutes, Senate Bill 14, amended as printed in the House Journal, March 21st, 2019. Amended on third reading as printed in the House Journal, March 22nd, 2019. The House has passed on third reading and transmitted the Riser Statutes, House Bill 1221, amended as printed in the House Journal, March 21st, 2019, and amended on third reading as printed in the House Journal, March 22nd, 2019. The House has voted to concur in the Senate amendments to House Bill 1078, 1035, 1191, and has repassed the bills as so amended. Message from the Revisor Statutes, March 22nd, 2019. We herewith transmit without comment as amended House Bill 1087, 1174, 1208, 1221, and 1225 without comment as amended Senate Bill 14. Delivered to the Governor for signature on Friday, March 22nd, 2019 at 8:42 a.m. Senate Bill 16, 17, 35, 68, and 103. Page 544, Senate Journal, 78th day, March 22nd, 2019. Appointments to conference committees. Senators Zinzinger, Chair, Court, and Cook were appointed as Senate conferees on the first conference committee on Senate Bill 106. On motion of Majority Leader Finberg, the Senate adjourned until 10 a.m. Monday, March 25th, 2019. Approved Leroy M. Garcia, President of the Senate. Attested Cindy L. Markwell, Secretary of the Senate.
Is there discussion? Senator Smallwood.
Thank you, Mr. President. I move the amendment to the Senate Journal dated March 22nd, 2019.
There is an amendment at the desk. Senator Smallwood, please proceed to the amendment.
Yeah, Mr. President, with your permission, I'd like to explain my amendment.
To the amendment, Senator Smallwood.
Thank you. I did move it. Yeah. So, colleagues, want to briefly explain this amendment to the Journal from Friday. I understand that it was a late night for everyone, and there was people were tired and a lot of stress. But what I've learned through almost 50 years of being a coworker or a boss or a parent or a husband is that generally speaking, you should assume best intentions, that people are trying to do the right thing. Sometimes they make mistakes, and that we should give latitude when those mistakes happen. So what happened for me, colleagues, is something that's probably not too dissimilar from things that have happened to you if you've been in the legislature more than a year or two, is that you had commitments that required you to be absent. And I've tried really hard in the 2.5 years that I've been here to make sure that if I know I'm going to be absent, that I get a substitute in place, that I ask for to be excused. And I haven't checked all the records personally, but I don't believe that I've ever been marked absent for any vote in 2.5 years of doing this. So what happened for me on Friday morning was, knowing that I was going to be absent that afternoon, I came here to the desk at about 8:45, and I spoke with Senate staff, and I said, what do I need to do if I'm going to be absent later on today and need to be excused? And we can all think back to January 11th when an email came out from Senate staff. We were all copied on it, I believe, that said, Please call or text in the event you are running late or need to be excused for the day. My cell number is this. Also, if you don't mind, please send me your cell number. Thank you. So for me, colleagues, I had assumed that in receiving this, that the protocol for being marked excused was to do exactly this, was to go to Senate staff. That was the email that I received. So on Friday morning, I came to Senate staff. What do I need to do in order to be marked excused? Senate staff said, you know what? There's a member of leadership on the other side of the aisle right there. Why don't you ask that person? I said, great. We came right here. We're meeting literally within these 3 square feet right here. And I asked, to the best of my recollection, for permission to be excused that day. And what I understood was that I was going to be marked as excused for that day. In fact, there's a little pad of paper up here that's got all of your names on it, colleagues. Next to my name, it was written excused and then highlighted in yellow. Okay? So, colleagues, put yourself in my shoes. You came up here, you did what you thought you were supposed to do, you followed protocol, somebody writes down on a pad of paper at the desk, excused, and highlights it in yellow. Okay? I stayed as long as I could. I don't think I left the building until probably 2:30 or 3. To then find out later on that votes happened late that evening where I was not marked as excused. I was actually marked as absent, as if I did not do my part in communicating to everybody that I needed to be excused for that day, for that afternoon, for that evening. So, and I apologize, colleagues, I have a terrible cold, but I've learned through this that even with a terrible cold, I'm not going to ask to be excused. So, until we get this figured out. So, think of this in any other context. Think of this for those of you who have children. Think of this in the context of your kid needs to be sick that day, or your kid is sick that day, or your kid needs to go to the orthodontist that day. And you go to your kid's teacher, and the teacher says, you know what? The protocol is that you go to the vice principal or to the excuse desk and let them know that your kid is going to be excused. So you do that. Then to find out later that what you should have done was go back to read the student handbook, because the student handbook clearly says that it is not up to the teacher, it is not up to the vice principal, it's actually up to the principal. Okay? As a parent, I know how you would feel. We could use the same example in employment. You should have gone back to the handbook. You shouldn't have listened to what your boss said or what the vice president of the company said. You should have actually gone back to the handbook, skipped protocol, and gone directly to the rules. So what I'm asking in the amendment, colleagues, and thank you, Mr. President, for indulging me in the explanation, what I'm asking for is exactly that. For you to look at the situation that I was in on Friday, given the information that I was given on Friday, knowing that most of you have been in that exact same situation before, nobody ever explained to me that the delegation that had obviously happened before, where we were told where to go to be excused, had been changed. I never got an email, I never got a text, I never got a phone call saying that that delegation process had changed. So all I'm asking, colleagues, we're not changing any bills, we're not adding any amendments. All we're looking to do is to go into the journal in those particular votes where I was marked absent and have it changed to where I would be marked as excused. I appreciate your time and consideration on this.
Is there further discussion on what I will refer to as the Smallwood Amendment to the journal, given that it does not have a numeric value to it, the numerator? Senator Gardner.
Thank you, Mr. President. I rise in support of Senator Smallwood's amendment to the journal, motion to amend the journal, and his request. And with respect, I was unclear as to the facts on Friday evening as to why my friend and colleague from Douglas County had been noted as absent, but subsequently learned that the facts were as he represents them to be here in the well this morning. Now, in my 11 sessions between two chambers, the written rule with respect to being excused has read in a particular way. Here it says excuse is made by the president. It doesn't say whether that's delegable or non-delegable. It clearly has been delegated, or if it was not delegated, a member of Senate staff, a very senior member of staff, took that power to themselves without permission of the president, and I do not believe that was the case. I believe the letter of January 11th was sent with authority, and I took it to be on behalf of the institution, the Senate, and the Senate President, because it was an official communication by the Secretary. And it indicated that in order to seek an excuse, one should speak with the Secretary. In fact, I have had 2 or 3 occasions due to personal circumstances to request to be excused. Have taken at face value that when I communicated that would be the case, that it was no doubt a matter of convenience to the president. And when I say a matter of convenience, I don't mean anything by that. It's a very busy position, and therefore that power or the authority had been properly delegated. Now, there are principles in organizational law, business law, about delegations, and delegations, powers delegated remain so delegated until revoked. And unless revoked, one is entitled to rely upon them. And my colleague from Douglas County relied upon that representation. And in fact, if it were revoked and not communicated, one could continue to rely. This is a matter of parliamentary procedure, parliamentary law, matter of general law. What it really is a matter of fairness. And so I ask for an aye vote that Senator Smallwood be noted as excused for all votes on Friday evening, March the 22nd. Thank you, Mr. President.
Is there further discussion? Mr. Minority Leader.
Thank you, Mr. President. Mr. President, I rise to confirm what the good senator, my colleague from Douglas County, has related. I did approach him Friday and asked that he delay his travel and not leave, and he did explain to me that that this was a pre-planned trip, did involve family, and he did indicate to me that he had been excused. Mr. President, I also understand your perspective, and I have reviewed the rules. It is clear that you are the one person who can excuse a member, but as the good senator from El Paso County stated before me, we were operating on the understanding that had been delegated to the Senate Secretary according to the email that was previously referenced. I can assure you, Mr. President, that the good senator from Douglas County was acting with the best intentions, and he and I both believe that he was operating within your will and intent. Thank you, Mr. President.
Further discussion. Senator Moreno.
Thank you, Mr. President. And on the amendment, colleagues, I'm not going to speak to the reasons why anyone may have been missing. I'm sure it was for a good reason. My my desire to speak today is about the rules. And part of me feels like I'm Tom Cruise in Minority Report. Because we're asking for things to be reflected that didn't actually happen. I too received that same email from the secretary, and I too have ran late in the morning. And every time I have texted, and I have the text messages, every time I have texted the secretary and asked, will you please let President Garcia know that I am running late? Because I have read the rules. This is not a handbook. They are the rules that govern the Senate. And under Rule 16, it states very clearly, no member shall be excused without the consent of the president. In Rule 20, call of the Senate, those absent shall be sent for and taken into custody by the sergeant at arms and brought before the bar of the Senate, where, unless excused by a majority of the Senate present, those for whose absence no excuse or an insufficient excuse is made shall be reprimanded by the president for neglect of duty and fined, respectively, at least to the extent of the expenses incidental to their apprehension or return. Colleagues, these are the rules. We had a call of the Senate, and thankfully it didn't come to the point where people had to be apprehended and fined. The consent of the Senate was not given to excuse those members that were not here. These are the rules. So for that reason, I ask for a no vote on the amendment.
Further discussion. Senator Bridges.
Thank you, Mr. President. My colleague feels like he is in Minority Report. I feel like I'm stuck in an Alanis Morissette song. Isn't it ironic? We have folks who have filed a lawsuit, this is unprecedented, who have filed a lawsuit over the rules of the Senate, asking that we ignore, for them, for that one instance, the rules of the Senate. And let me be clear, the reason that we were here until so late on Friday was because of discussion at length, which is within the rules. It was because the bill was read at length, which is within the rules. And within the rules, that bill had been scheduled for discussion that day. And then a third of the people who are now asking for a change in the rules were gone for that vote. But let's ignore the rules in this one case. Let's ignore the rules and be gracious. I think that this body could use some grace right now. I think it is especially ironic that this ask is coming after the Journal was just read at length, something else that certainly is within the rules, but is certainly not how this body typically operates. So the question right now before us truly is, the true question before us right now is not, what are the rules of the Senate? The question before us right now is, how do we want to be? How do we want this body to be? How do we want to treat each other? What is this place? We can operate on the rules for the rest of the session, and everyone's going to hate every minute of it. I can tell you, I came over from the House this session, and I was looking forward to being here, and this is insanity. This is not how this body should operate, even though it's within the rules. This is not how I expect this body to operate. I don't think it is how the people of Colorado expect this body to operate. So my question is, if we want grace in this chamber, is this a one-time, specific, small kind of grace? Or is this the kind of undeserving, loving grace that I learned about in divinity school? And will this be the kind of reciprocal grace that, dear God, this body could use, and that I truly hope we will grant to one another? I urge and I vote. Thank you.
Is there further discussion? Senator Smallwood.
Thank you, Mr. President. And colleagues, I appreciate your comments. To be perfectly clear, I think we should operate within the rules. But again, when I receive an email that says, these are the rules, and I operate off of those, I think, based on who the email is coming from, that I should be able to act in good faith on that information. And I'm sure you're right, colleagues. We can debate the letter of the law all day long. What I wanted you to hear from me is, this is the email that I got. This is what I was told to do, how I was told to do it in this chamber, and it's how we've been operating as a body since January 11th. It doesn't say in this email, make sure that you also copy in the president, make sure that you ask me specifically to make sure that the president is notified in this. This is a two-sentence email. This is how I was operating. So I guess what concerns me the most about this, colleagues, is this building still, at the end of the day, has a lot to do with relationships. And to be able to rely on information when a colleague tells you, this is what I'm going to do, this is what you need to do, to be able to take that information and be able to rely on it. And if that has changed here, it's unfortunate, but I understand. This was just an email from the senior Senate staffer. It's not a copy of the rules. It's just an email telling me what I should do going forward. And hindsight 2020, you know what? I should have just probably taken this and said, thank you very much, but I appreciate that you're telling me that these are the rules that I'm supposed to operate under, but you know what? I've read the Senate rules, and I don't care about your email, ma'am. I'm instead going to contact the president directly. So thanks, but no thanks. I just don't think that's realistic, colleagues. So if this is how we're operating from this point forward, I understand. I get it. Thanks for taking the time to listen to me, and would hope that you'd vote in support. Thank you, Mr. President.
Further discussion on the Smallwood Amendment. Senator Gardner.
Thank you, Mr. President. Well, I appreciate the comments of my friend and colleague from Arapahoe County, but as I think I've said before in the well, I do not have a degree in divinity. I have 2 degrees in the law, and of those, parliamentary law was one of the things that I dabbled in. And I appreciate, as a person of faith, the Christian tradition, I appreciate the appeal to grace. And if that is how one must reach the decision to excuse my colleague from Douglas County, then I ask you to do that. But my appeal was not to grace and forgiveness for a mistake made, but rather an acknowledgement of the rules and the law that were followed. The rule is, as the senator from Adams County states, that the president is the one who has the authority to excuse. Now, we can make a couple of different conclusions here. One conclusion is that's not a delegable power. And if that's the case, then for 80 days, 78 days, I suppose more accurately, we have violated that rule over and over and over again.
Will the good senator from Senate District 12 please not impugn the motives of the president?
I'm sorry, Mr. President, did you? So it was either delegated and can be delegated or was not delegated. The practice was that it was delegated. And therefore, the right and appropriate thing under the rules and under parliamentary law is to recognize Senator Smallwood as excused. If you cannot see your way to that because that is not your framework of reference, I nevertheless implore you that the right vote is to amend the journal as requested by the senator from Douglas County. Thank you.
Is there further discussion on the Smallwood amendment to the journal? Seeing none, the motion before the body is the adoption of the Smallwood amendment to the journal. All those in favor say aye. Aye. All those no? No. The noes have, and the amendment is lost. There is an amendment at the desk. Mr. Carpenter, please read the amendment.
Amend the Senatorial March 22nd, 2019, strike excuse 0, absent 5, and substitute excuse 1, absent 4 on page 537, line 29, page 538, lines 134 and 51, page 539, lines 13 and 37, page 540, lines 125 and 50, page 541, lines 15 and 37, page 542, lines 1 and 49, page 543, line 8, strike Scott A and substitute Scott E on page 537, line 36, page 538, lines.
Scott.
Thank you, Mr. President, and good morning, colleagues. You heard some great arguments about the Smallwood amendment, so now we have the Scott amendment, which is identical to the Smallwood amendment, asking for myself as being excused versus absent on Friday. I think what we're learning is that old saying, the road to hell is paved with good intentions. And I think that's kind of where we're at with some of what's going on here. I know the rules. I've been here for 8.5 very long years. So I get the rules. And I also get the common courtesies that we've all shown to each other over the years, whether we be in the minority. I've done that before. I've been in the majority twice. We get all that. So yes, did we get a little lazy with the rules? Sure, it happens. But I guarantee there's been committee hearings. There's been a lot of work on this floor. And we have not followed all the rules. We get that. On Friday, doing my job as the minority whip, I had talked to the members that were departing for whatever reasons they are, which don't matter, quite frankly, right? They don't matter why people were departing. Talked with the minority leader and just told him the members that I knew that were going to be departing. He was fine with that. Matter of fact, we joked around a little bit that we could stay gone for another 45 days if we'd like. And that was a joke, which we don't laugh much around here anymore, but we should. So we joked around a little bit, but as in the past, we've had these same conversations, and it was understood. It's just a communication thing we've all done. So I did send a thank you note to the minority leader, just simply thanking him for excusing the few of us that have to travel so far, and told him it was appreciated because he's done it before, and it is very much appreciated when people have to travel as far as a few of the members in this room do. And lots of folks can stand around and say, well, gosh, we know that. But until you do it for the number of years we've done it, no, you don't really understand. So it is appreciated when we are excused, when there's reasons for us to go. We all have weddings, and geez, we've got all kinds of crazy things going on at home. And we are citizen legislators. Some of us still have a business to operate. That's an amazing fact. Some people lose that in what we do. But I think it just kind of goes back to communication. Yes, we understand the rules, but we also understand there has to be good communication. Had we been informed at 1:35 p.m. on Friday that the minority leader was going to talk to the president and let us know that, hey guys, all bets are off, don't budge, we wouldn't have budged. Now maybe somebody would have taken the chance and said the heck with it and gone. I don't know. I can't judge that myself. But there was ample opportunity to let us know, however you wanted to communicate it, that something's changed, something's different. We are no longer going to do things the way we've done them. And at least we would have known in advance. So did we violate the rules? Absolutely we did. Absolutely we did. And I understand why the majority is not very happy with us right now. Go figure. So we're in kind of a weird tug-of-war back and forth. And how that tug-of-war ends, I don't know. It's unfortunate, and I hope we're able to get past these issues and get on to business as usual. I've never seen a fight yet that wasn't 50% on both sides. It's just the way it is. With that, members, I would ask you to support this amendment. Again, we had good intentions. Had it been communicated to us that we are now under a new realm of the rules and how we're going to go forward, we know now, and it won't happen again. Thank you, Mr. President. I urge an
Senator Scott, for the record, can you please move the Scott amendment to the journal?
I'm sorry. I move the Scott amendment to the journal.
Is there further discussion on the Scott amendment to the journal? Senator Court.
Thank you, Mr. President. We're discussing the way the Senate functions. It's relatively esoteric to the people out there. But what matters to the people out there is that we are here to discuss policy. We are here to debate what the people of this state want us to do. On Friday, we spent 10 hours debating a bill that there is great passion about on both sides. We spent 10 hours on that bill. By the time we were done with it, several members of this party were gone. We are here to do the people's work. Regardless of the esoteria of our rules, we are here to do the people's work. I don't know if many of you who served with me in the House remember that several years ago, my mother-in-law was in the hospital all night long in the emergency room with surgery. The next morning, I had a bill up in the Appropriations Committee. I left the hospital where my mother-in-law could have been dying, and I came here to do my job, because that is what we do. We do our job. We are elected to be here for 120 days every year. The people really care about the policies we debate. That is the job. Yes, we can have discussions about the esoteric rules under which we function, but the job is to debate policy and try to do what is best for our constituents. And when we leave, we aren't doing that. Thank you.
Further discussion. Senator Gardner.
Thank you, Mr. President. And I want to be clear, I did not quite understand Mr. President's admonition when I last spoke. I certainly do not question anyone's motive. In 30 plus years of law practice, one of the most difficult things to divine for judges, juries, lawyers, and everyone is what someone's motive might be. I don't know. My plea is to the rules. Now, My friend and colleague, the senator from Denver, just spoke to us about doing our job and not being absent, and I agree with that admonition. I have had very few absences, even when my presence was an act of futility. But I do not judge my colleagues as to what they believe is a reason for their absence, because I would not want them to similarly judge me or my motives, Mr. President. I appreciate the admonition of the senator from Denver that we all should take our duties here to discuss policy very seriously. But that's not the question before us. The question is not whether my colleagues took their duties seriously. That may be a discussion for another day about their request to be excused and whether or not their request to be excused ought to have been justified or ought to have been granted. Mr. President, my assertion to you is that their excuse was granted. The rule certainly says the president grants excuses. We have a letter dated January the 11th, which, unless someone wishes to say was not done with authority, I fully believe it was done with authority. It was acted upon for 75, 78, even till this morning, probably 81 days, it was acted upon. It was acted upon in reliance by members. Now, should those people have asked for an excuse, I say to my friend and colleague from Denver, a discussion we can have with our colleagues. But did they properly ask to be excused? Under the policies and procedures set forth in a letter dated January 11th, under the authority of the President of the Senate, they did. Were they excused? Under the authority and the procedures that had been instituted under the authority of the President on January 11th, 2019, and acted upon for 80 days, they had. And to not grant these motions is to abrogate the policy and procedure that was acted upon for some 80 days. I don't know why it suddenly changed. I don't assert any motive. I don't impugn any motive. I simply say it is wrong. If that letter and the authority of that letter has been withdrawn, it is still effective until it is communicated. And to do otherwise is wrong, it is unfair, it is unjust. And I ask for an aye vote on this motion.
Mr. President.
Thank you, Madam President. Well, I think the members know that it will be far and few times that I come down here to address the body, because that normally should not be, under customs, the way we do things down here. But I think we would all recognize, for those of us who have served in this wonderful institution, for me, it's been for the last 6 years, both in the majority, in the minority, and now in the majority, that there's a lot of unset precedents that have been established. And it was made very clear a few weeks ago that while some in the minority party may not agree with all the decisions of the president and extended to the secretary, as is being impugned today, that we should rely on the rules to govern us. Rely on the Constitution. Obviously, yes, the Constitution is very important. It's one of the reasons why, after I graduated high school, I enlisted in the United States Marine Corps, served in Iraq in 2003. And furthermore, picked up the deceased fallen Marines who were killed in combat to fight for this Constitution. So to sometimes imply here, very cutely, that those of us in the majority don't have a respect for the Constitution or the rules that govern this body is unacceptable. The standard has become, when we don't like what the standard is, we can interpret it a little differently. We can imply that it might mean under these circumstances this. Well, I think we can agree on one thing today, that the senatorial courtesy that has existed here for many years is in question. And that was started, not on behalf of us, but at the request of reading at length and ad nauseum every single thing we can. In the last 6 years, while I served in the minority party, not one time did we ever read the journal at length, let alone now multiple times. As I reminded the minority leader today and on Friday and in the past, we will do all we can to extend a hand, to work across the aisle, to establish new diplomatic relationships. But we have a job to do. And like it or not, Coloradans have elected us to be in the majority. There was a call of the Senate. In each of these cases, your members will confirm that not one of these members consulted with me as to whether or not they could be excused. And under the rules, that is the discretion of the president. So I renew the opportunity to continue to work across the aisle and to do the work that people sent us here to do. That offer has always existed and continues to exist.
Is there further discussion? Senator Bridges.
Thank you, Madam President. Right now, this is when we get to decide what the next 40 days and 40 nights are going to be like. After this discussion, which is not about the rules, regardless of what anyone up here says, this is not about the rules, this is about the norms that the Senate runs on. This is about the common courtesy we extend to each other. Democracies run on norms. And right now, at every level of government, apparently, including this one, those norms are being thrashed. The glue that holds us together is being sacrificed in the name of rules. So when we finish this debate, when these votes are over, the question is, are we going to read at length again? How's the budget process going to go? Run your amendments. This is the premier time for the minority to run all of the things that they wish they could have run all year. Do that. But are we going to read the budget at length for 20 hours? Are we going to read the journal at length? The model of having the reading of the journal excused is such a central norm that this placard right here is on this desk 24/7. I move the reading of the journal be dispensed with and the journal be approved as corrected by the secretary. This is laminated and it is on this podium right here 24/7. So the question is, are we going to get back to a place where we are respecting each other, where we are following the norms that hold our republic together? Or are we just going to keep acting like a second-grade classroom? Thank you.
Further discussion. Senator Gardner.
Thank you, Mr. President. Well, I take exception to the assertion that we're behaving like a second-grade classroom. Democracies do run on norms. Rules are amongst the strongest norms. And I have been in the General Assembly, as people are probably tired of hearing me say, I'll just say it this way, over a decade. And my experience with sort of civility norms versus rules, which are a different kind of norm, is this. If one wants to live by the rules and deny the norms, one will get the rules in return. So, it is within the rules to introduce a bill and read it across the desk on a Friday. And it is quite within the rules to have it heard in committee on a Tuesday. In fact, I was told that's within the rules. But I have to say, in my experience of a decade with the norms of this body and the body across the way, unless a bill was non-controversial and needed to be done, that was not one of the norms. Introducing a bill on Monday and reading it across and assigning it to committee is within the rules. And scheduling it in committee on a Wednesday is within the rules. But if it is a controversial bill, it is not within any norm that I ever experienced in this body, or our sister body across the way. Not a lower body, our sister body. And so we have fallen to the rules. I accuse no one of not having respect for the Constitution. I have accused many, accused is too strong a word, I have asserted that many have an incorrect understanding of the Constitution. But how did we get here? I say to my friend and colleague, we got here because the majority failed to follow the norms. And I learned one thing very quickly as a minority member, of which I have been a minority member more than any other thing in that decade of service, is that legislative minorities who are legitimately elected, I say to my friends, legitimately elected by constituents who strongly believe, just as strongly as your constituencies believe, a set of things. And they charge us, they implore us, they send us emails, phone calls, letters, and come to our town hall meetings and demand of us that we stand up for what they believe. Now, in a body, a legislative body in which norms rule, norms over written rules, norms of civility and comity, the ability for the minority to make its points, not simply in the well, because that is of limited utility, quite frankly, but to do so back there, and across the street in a conference room, and to bring one's stakeholders to the table, and maybe, no, not maybe, quite certainly those minority stakeholders will not receive what they want, but they will be heard. And I understand there's disagreement about whether they were heard or not heard. But I know they can't be heard between Friday and Tuesday, between Monday and Wednesday. They can't even get heard in committee. One wants to speak of norms. The norms were violated. Colleagues, the norms were violated. And so there's nothing left than what a very wise caucus leader of mine told me when I was a freshman, we had freshmen in those days, you have the calendar and you have the rules. Whenever the norms fail, all you have is the calendar and the rules. Now, I'm supposed to be speaking. I appreciate your indulgence, Mr. President, because others took the conversation in this direction. I'm speaking to this motion, and the motion is on the rules and the law. The rule says the president can excuse. The law says when that is delegated, so long as it is delegated, and it has been delegated, then a member can rely upon that. That is all. That's a norm as well. And if we want to get back to the norms, then let's vote yes.
Is there further discussion? Mr. Carpenter, would you please add Senator Priola to the roll call? Mr. Minority Leader.
Thank you, Mr. President. Mr. President, I am grateful for your indulgence, your patience as we discuss this motion. I am also grateful to the good senator from the Cherry Hills Village area, Centennial and Arapahoe County. I do not have a degree in divinity, and I'm torn now at 58. If I had it to do over again, would it be divinity or law? Certainly not two of them, or both. Faith came to me late in life, and one of the things that I have learned is that we are to pray for wisdom, the wisdom of Solomon. Mr. President, I think we have had a great deal of wisdom conveyed to us here this morning, and I would ask, Mr. President, if you would be willing possibly to take a Senatorial 5, and maybe you and I, if you choose others, might join you for a discussion as to how we might find that way to do what Solomon did and find a way to move forward. Mr. President, it is an honor and privilege to serve with you. I ask your forgiveness, sir, for any insult that I have offered to you in this session, and I would welcome an opportunity to take a Senatorial 5 and discuss with you how we might move forward. Thank you, Mr. President.
Thank you, Mr. Minority Leader, for that request. I think seeing the business we have before us, I will leave that offer absolutely available and would welcome that concluding business today so that we can have that kind of a conversation. Is there further discussion on the Scott amendment to the journal? Senator Scott.
Thank you, Mr. President, and thank you folks that have chosen to come up and make some comments on both sides. I think that's very important to the dialogue going forward. With that, all I can really do is renew my motion and ask for an aye vote on the Scott amendment. Thank you.
Motion before the body. Mr. Majority Leader.
Thank you, Mr. President. Never thought I would be coming to the well to discuss whether someone was excused or whether they were absent or whether they were present. It doesn't seem like that is really the business we were all elected to be debating. I wasn't going to say anything, and I'm not sure if there will be 3 more amendments that look similar to have this discussion, but I figured I'll say a few quick words right now. I think if anyone is still watching, I hope they're not, they might be confused about what we're doing here today. And so I just wanted to offer a few quick thoughts. This building, this chamber especially, runs on what we call senatorial courtesy. I think we can all agree, without pointing fingers, that a lot of that courtesy has gone out the window a bit this session. I think we can all agree and disagree on when that started, but I'm not sure it matters right now, whether it started because of a bill going to a committee or whether it started because of a member asking for his own bill to be read at length when it just happened to be the longest bill we will ever see this session because supposedly folks were confused about what the bill did, even though it was their bill. I think we can all agree there have been some breakdowns in the courtesy that really fuel the business that we do here in an efficient manner. Last week, even in light of feeling like all those courtesies have been out the window, the minority party came to me, and after a long afternoon or a long day of reading just about every bill at length on the calendar in order just to delay and make things take longer, they said, well, if you agree to lay over Senate Bill 5 and House Bill 1177 until tomorrow, this will all stop. We will stop reading bills at length. To me, that felt like a little bit of a threat. Felt like we have this process of debating bills, of hearing bills, and a rule or a norm has changed. And I felt like it was, and I don't mean this with disrespect, but I felt like it was being weaponized to stop the business of this chamber. But out of maybe a moment of courtesy or just a feeling of maybe we can start talking again and resetting some of these relationships and these norms, I extended the courtesy and said, okay, if you will stop reading these bills at length, let's lay over House Bill 1177, Senate Bill 5, two bills that I know are very important to everybody in this chamber, but for different reasons, very important to the minority party. I agreed to do that. So they, as normal, ended up on the calendar for the next morning, which was Friday. And then we have a debate. We begin the debate immediately. And a third of the caucus of the minority party essentially leave for different reasons, legitimate reasons, etc. But I want to make sure it's clear that we had that debate on a Friday because it was requested of us to have that debate that day. And yes, we were told this morning that there were trips that were on the books for a long time, and that's fine. But there was no hijinks. Those bills were on the calendar and should have been debated Thursday evening. Frankly, it should have been debated Thursday morning, but because everything took so long because of the reading of bills, it was Thursday evening. We do need to get to a place where senatorial courtesy is how we run things around here once again. I hope we can get there. The analogy has been said several times that, at school, the parent talks to the front desk and excuses their child, or that we are running as a second grade classroom. We are not children. We are not in grade school. We are senators. We are in the Colorado Senate. I hope for the rest of this session we can act like it.
Further discussion. Senator Sonnenberg.
Thank you, Mr. President. For those of us that have been here a long time, there's one person in this chamber that's been here longer than me. We're the two longest serving legislators in this building. This is painful. I've served in the minority more than I've served in the majority, and it's never gotten to this before. Matter of fact, I was so frustrated, I wrote a column expressing my frustrations, which now has caused more frustration. And I'm not pointing the finger or blame, because in any scenario, there's enough blame to go around. There's enough blame in this process on how it works and how it doesn't work, and who was in the majority and who was in the minority. And I remember the other night when a colleague from this side moved to rise and report, and it upset everybody on this side.
And I remember the same thing happening in the House 8 or 9 years ago, the opposite way. But we have never gotten to the point that we have, I would argue, this year, where both sides seem to double down every time something goes south. And we do have a choice. The good senator from Cherry Hills talks about we have an option. But it's got to be a mutual option. Was it Cherry Hills? Did I screw up? Dadgummit, I apologize. The good senator from Greenwood Village is right. We have an option. We have a choice. We have 39 days left, but who's counting? To either figure out how to work together, how to quit doubling down. Because from my perspective, and I think what has happened now makes my op-ed even more applicable. Now, were there statements in the op-ed that were taken wrong? Absolutely. It appears there were. I apologized for that. When we get to 1177, I'll talk more about some of that, but we're not to that point yet. What I want to talk about now is, how do we move forward? What is the new norm? And how can I have a conversation with anybody over here, or how can anybody over here have a conversation with me with the cloud that everybody has taken this personal? And for some of us it is. For the good senator and I from Aurora, that's the way it looks now. We have seen things change. Her in 15 sessions now, me in 13 sessions. Change to change from a citizen legislature in which we wanted to solve problems and we could disagree and continue to disagree and yet go out and have dinner or lunch and still have a conversation. Now there's people afraid to even have a conversation with me or some of my colleagues, and quite frankly, I am scared to death to have conversations with others in the chamber as well. So how do we move forward? What is the norm? I can tell you whether or not those 5 individuals are marked absent or excused really doesn't make a hill of beans. I don't think it'll affect any of their constituents. I don't think it'll affect any of their campaigns. I don't think it'll affect anything beyond what has happened here today. But I'm actually thankful that this happened so we can have this conversation. Because I think it's a conversation that is long, long overdue. And I'll emphasize again by saying that I saw this at the beginning. I think my colleague from Aurora saw it at the early onset of the session, and maybe even some from last session when we had a different party in power. And it continues to escalate, and it continues to get worse, and it continues to make an environment down here where we forget about solving the people's problems, dealing with the issues that we were sent here to deal with, but rather, how do we figure out how to put the other person in a box? It needs to stop. And Mr. President, I'm willing to wait here all day. If you and the minority leader and the majority leader, or whoever you'd like, would like to go have a discussion to figure out how we move past this. Because I don't see it getting any better until we have that frank conversation. I want it to be better. I want to be able to smile again when someone comes up and makes a joke. And actually, I want to hear a joke again. Because those have been lost as well. Our ability to enjoy each other's company and have a good, friendly discussion seems to have gone away. And yes, I wrote a column about that frustration. If I wrote it today, it would probably be even more harsh because I think it has gotten worse. I ask for us to stop that. I ask, Mr. President, that we no longer do this, that we actually sit down, figure out a path to go forward over the next 40 days, come back in here and conduct business as one body, the Colorado Senate, as a body that we can be proud to serve in and go back to our constituents and say, yes, I represented you to the best of my ability. I still have my other job. I am a citizen legislator. I make mistakes. Lord knows in 13 years I've made a lot of them. A lot that I'd like to have back. A lot that I've apologized about. I'm going to ask for a yes vote on the amendment in hopes that we never have to take this vote, that the president, the minority leader, whoever the president would like in that discussion would take a moment to go in another room and see if there's a path forward. With that, Mr. President, I thank you for your indulgence in allowing me to talk about more than just the amendment, to talk about what I think is the root of the problem here and solve this issue. Thank you, Mr. President.
Senator Todd.
Thank you, Mr. President. And I want to thank my colleague from Sterling. And we've served together for 13 years. And you're right, I've been here for 15, and it's troubling. It is beyond troubling to me where we are. I consider many people on both sides of the aisle to be friends, to be colleagues that we have laughed together, we've cried together, we've prayed together, many of us on different occasions. But we are at a standstill. And I said a couple of weeks ago, we can do better. I know we can do better. I believe we can do better. I also made the statement that there is no one bill down here that is more important, that oversees what it is doing to us as a Senate. There is no one bill that is that important. Every bill that is on the calendar right now could die at the risk of us not being able to work together. And Colorado would not be better or worse for it. That's my opinion. This has been a tough session. It's been a tough session for a lot of different reasons. And as we were sitting here Friday night, having sat in the minority before, knowing that it's pretty tough. It's pretty tough to sit there and say, you know, not one of our members is down there talking about a bill. Or if we are, we're bringing an amendment and it's not passing. And that's frustrating. Coming together and figuring out what are our best solutions. It's not Democrat, it's not Republican, it's Colorado. It's not urban, it's not rural, it is Colorado. And how do we come back to that? And how do we bring back the dignity? Every one of us is tired of the game playing, the reading at length,
the counting someone absent, any and all of those different issues. We need to move forward. We need to move past this. I recognize and understand many of the bills that are coming forward are bills that were on hold because of the majority party being in the minority. And this is an opportunity to jump back in and bring legislation forward. My greatest sorrow is that in many cases we're not having those conversations across the aisle, or when we do, we're not moving it forward. How we change that, how we address it, and how we make sure that we are really looking at the big picture and the big spectrum, that's the biggest challenge. I have utmost respect for every person in this chamber. Your constituents sent you here just like mine sent me here. We are representing a wide spectrum of people. Mr. President, I would also like to urge you and the minority leader and whomever else you feel need to be present for us to take a Senatorial 5, for us to take a time, because going ahead and saying we're going to plow through, there's no bill that's that important to do if we don't have peace in the valley. If we don't have peace in this chamber, we're making a pretense. I would urge you take this time and for the rest of us to commiserate, to have conversation. It's not going to solve the amendments, the excusing, and someone was absent, not absent. It's not going to solve it, but what we are going to do is take a time out for our leadership to figure out how to listen to one another and how to move forward. With that, Mr. President, again, I would urge that there be a Senatorial 5.
The Senate will stand in a recess so that the minority leader, majority leader, both assistant leaders, and the senior ranking members of both caucuses can visit. The Senate will come back to order. The pending item before the Senate, before the recess, was the Scott Amendment to the Journal. All those in favor say aye. Aye. All those no? The noes have it, and the amendment is lost. Mr. Carpenter, there is an amendment at the desk.
Thank you, Mr. President. I move Crowder Amendment to the Journal.
Mr. Carpenter, prior to that, Mr. Carpenter, would you please read the amendment?
Amendment Senator March 22nd, 2019. Strike, excuse, 0, absent 5.
Senator Crowder.
Thank you, Mr. President. You know, I think I can relate to you what happened on Friday. That's in my 7 years here before that had never happened before. And that was a situation where it was going to be a late night. And what I did was I contacted the minority leader, then I told him my plans, and you know, he somewhat gave me his blessings. And so anyway, I went home. I left here about 2 o'clock. You know, there's, I'm not trying to make excuses, but in the 7 years that I've been here, that's the first time that's ever happened, when we had a situation, a late night Friday night. And you have to realize, those of us from rural Colorado, I don't go home every weekend, I go home every other weekend. So my first priority as a senator is the Senate, but my higher priority is my wife. You know, I think that it's important for me to, as the head of a household, to make sure that we make contact. We talk on the phone every day quite a bit. But the reality is, I've been married 47 years. And you know, in that relationship that I have with my wife, we have to make contact. So it's very important to me to make sure that every other week I see her. And what this does is basically, it's as much for me as for her, because it's about attitude. You know, I personally, I think I've got a great attitude up here. And to make sure that she's okay too is vitally important to me. And I will not, you know, if it happens again, I'll probably do the same thing. I'll go to the situation about going through the motion to get excused, but, you know, I will continue to make sure my family structure at home is fine. And it is fine. You know, we got a great relationship, and the reason it's great is because I make that effort to get home. And I will continue to do so. You know, I think the things in the past here, hopefully they can resolve itself. But I also am right along with the president. I come in here in the minority, and we went to majority and then back to minority. I've never seen it like this. All the time we were in the minority, nothing was ever scheduled that late on a Friday, to my recollection. And the reason I went to the minority leader, since this is the first time that ever happened, I thought the chain of command, maybe the president can relate to the military, but normally we go through the chain of command of the military, you know, whoever our leadership is, and then he goes on forward. And I understand the rules, you know, but I think that, I think that, you know, I might have broken the rules, I don't know. That's up to you to make that decision. But the reality is, my first priority is to my family. You know, so we don't have, my sons are grown, and the grandchildren need attention, to make sure that there is no dysfunctional family in the future, to make sure that everybody is very stable in their respective duties as grandchild, child, whatever. So, and I think it's important to realize that those in rural Colorado do not bring their wives with them. You know, I think that it's something that's important for me to continue doing, and I will. But I think that, you know, this has been a very tumultuous session. But in the reality, in the minority, when I was in the minority the first 2 years, we got a lot done. You know, we got a lot done up until this year, but everything has been rejected from this side or whatever, and that's the way it goes. But I think the biggest, you know, we're talking about rules. I think when you start talking about the rules, you have to include the Constitution, and you have to realize that the biggest the biggest, in my opinion now, the biggest difference between the two sides, and the President touched on it earlier, that the Constitution of the United States is flexible. And I do not believe that. The oath that I have taken have taken this, this greatest instrument in the history of mankind, which is the Constitution, and said this is the Constitution which binds us as a country. Now, if we don't like those constitutional issues in the Constitution, we move to change them completely. But to say that they are flexible is where the biggest problem is. And I understand that this goes down to the rules that we're talking about. You know, as long as the rules are in play for everybody to benefit from, as a group, as a whole, I'm all in favor of it. But once those rules get in the way of a higher calling, which is your family, you know, I have no, you know, my first direction is my family. You know, this is a temporary deal that we're in here. This is my 7th year. I've got 1 more year to go, and I will be term limited. But the family is forever. And I will continue to support that family, whatever it takes. So, Mr. President, I guess, you know, the thing about it, I thought I was doing right by going through the chain of command. And, you know, the oath I took to this body is very important, as well as the oath that you and I, Mr. President, have taken in the military. And, you know, I will uphold that oath, and, you know, I will, I guess I need to somewhat apologize to the body for not going exactly through the rules. But again, this is the first time that's ever happened, that on a late Friday night, even when I was in the minority, everything was scheduled Monday through Thursday. Even in the minority, there was never a situation where that happened on a Friday. But I just want you to know that, you know, I try and abide by the rules as much as I can. But if it gets in the way of my family responsibilities, there's a problem. And like I said, I will always put my family first. And I hope the meeting that you all had back there was productive. You know, one thing that I've done while I've been a senator up here is I've never applied for, nor have I asked for either chair or vice chair in a committee. And there's a reason for that. I'm up here to represent my district. I'm up here to represent the people in southern Colorado and southeastern Colorado. Not to be a chair, not to be a vice chair. It gets in the way in my productivity, in my opinion. So I think that, you know, if you look back on the first year, I made some judgments on bills. And the first one, basically out of the box, was 2013, the Medicaid expansion for the state of Colorado.
To the good senator from Alamosa, I just want to stick to the confines of the amendment, which is to amend the journal.
I'd just like to, you know, that one issue, I did vote, I was the only Republican in the state of Colorado who voted for Medicaid expansion. Not because I was going against my caucus, but I was going for my district. And in the spirit of, I won't take up no more of your time, Mr. President, but in the spirit of cooperation, you know, I thought I would compelled to come up here and tell you the reasons I did it. And I'm not going to, you know what I'm not going to do, I'm responsible for my own actions. But I will, I appreciate people coming down and wanting to speak to and from it. But at this time, Mr. President, I think what I'm going to do is withdraw my amendment request and just go from there in the spirit of unity. So I withdraw the amendment.
Senator Crowder's amendment will be withdrawn at request of the sponsor. There is an amendment at the desk. Ms. Carpenter, please read the amendment.
In the Senate Journal, March 22nd, 2019, strike excuse.
Senator Quorum.
Thank you, Mr. President. I move the quorum amendment to the reading of the journal.
To the amendment, Senator.
Thank you, Mr. President, and I would, with your indulgence, I would like to explain my reasoning.
Please proceed, Senator.
We've talked about jobs and responsibilities, and I take them all very serious. This is the second most important job I've ever had in my life. The most important job I've had in my life is that as of a husband and a father, and I take that serious. Friday night for me began a little over 4 years ago. We are moving into the apartment just a couple of days before session starts. My wife, Diana, who is one of the hardest working women I've ever known in my life, besides being beautiful, she's hardworking. It's a great combination, I got to tell you. She wasn't much help. And I said, what's wrong? She said, I just can't do it. I can't do it. I said, well, maybe we need to take you to a doctor. She said, take me home. So I did. I got her to Grand Junction. Her blood pressure was 190 over 150. She had 19 pounds of water in her chest cavity. She had reaction to a medication. Her doctor had died. She had a lung infection. She couldn't find another doctor. So she went to an urgent care facility. They prescribed a Z-Pack and 2 steroids. She had a reaction. At the hospital, they said, I'm sorry, you have congestive heart failure. Thank you, and go home. She was released without a doctor, kept overnight. We start session, she's still not doing well. And I get a note from Governor Hickenlooper. Has Dinah found a doctor? No. In a very short time, I got a call from Jeff Thompson at the University of Colorado Hospital. You need to get out here right away. I'll meet you at the front door. So we did. She got with Dr. Buttrick, her cardiologist, for, as he said, till I die or you die. Put her on a regimen. And I think Dr. Buttrick probably wants to take credit, but I think the true story is the Lord didn't want her at that time, and the devil was afraid of her. So she recovered. But she is very prone to pneumonia. 3 weeks ago on Friday night, when I arrived home, and about 2 hours later, she became very ill. She had the flu. She's had it for 3 weeks. Probably lucky I wasn't home the first week because, one, there's nobody there to take care of her. My son hasn't been in Mexico. She was unable to get out of the bed to even bathe. When I got home Friday night late, I walked in the house and kind of regretted that I came home. That's a little humor, folks. But she called me Friday. She said, I'm not doing well. I hope this is not going into pneumonia. And Dad, who was 88 years old, Korean War veteran, just got out of the hospital with pneumonia. So she's been no help to him. So I told her I will be home. I said we are on some contentious legislation, but it's second reading. I will be home. I jokingly talked to the majority leader that morning, told him that I was be going home. The comment was, I don't care. I said, good, I'll take 2 Democrats with me. Later that afternoon, I talked to the Secretary of the Senate and said, I need to go home. Diana's needing the help, and I need to be there. And frankly, me being here is not going to make a difference. So I left. And I went home, got home late. I spent 15 hours this weekend driving. I got a text from the minority leader, said there was a call of the Senate. And to probably need to apologize to the senator from Denver, who's not very happy about texting and driving. But I did respond that I'm on 50 headed west. I got home about the time that you were finishing up the session. And members, I do take this job serious. But if it happens again, and my wife feels that I need to be there, remember, no, you're number 2. I am frustrated with what we are going through at this time. I look around and I see what's going on in this body, and I've always bragged that we are not like Washington, D.C. Members, if we're not there yet, we're getting damn close. I worked for a very smart man when I was young. Yes, I was young. It's hard to believe, but I was young. And he probably gave me the best advice in my life. He said, never argue with a fool. A bystander can't tell the difference. And unfortunately, we are all human. We all make mistakes. And we are responsible for our own actions. I take responsibility for my own actions. I once again move the quorum amendment and ask for a roll call vote.
Is there further discussions? A roll call vote has been requested. Mr. Carpenter, please poll the senators.
Senators Bridges, Bridges, aye. Cook, Cook, aye. Quorum, Quorum, aye. Court, Court, aye. Crowder, Crowder, aye. Danielson, 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 no. Donovan, Donovan, no. Binberg, Binberg, aye. Fields, Fields, aye. Foot, Foot, aye. Gardner, Gardner, aye. Janal, Janal, aye. Gonzalez, Gonzalez, aye. Hill, Hill, aye. Heisey, Heisey, aye. Holbert, Holbert, aye. Lee, Lee. Lee, aye. Lundeen. Lundeen, aye. Marble. Marble, aye. Moreno. Moreno, aye. Pedersen. Pedersen, aye. Priola. Priola, aye. Rankin. Rankin, aye. Rodriguez. Rodriguez, aye. Scott. Scott, aye. Smallwood. Smallwood, aye. Sonnenberg. Sonnenberg, aye. Story. Story, aye. Tate. Tate, aye. Todd. Todd, aye. Williams, excused. Winter. Winter, aye. Woodward. Woodward, aye. Zinzinger. Zinzinger, aye. Mr. President.
Aye.
Mr. President, aye.
With 32 ayes, 2 no votes, 0 absent, 1 excused, that amendment is adopted. The underlying question before the body is approval of the journal. There is an amendment at the desk. Mr. Carpenter, please read the amendment.
In the Senate Journal, March 22nd, 2019, strike excused 0, absent 5, and substitute excused 1, absent 4 on page 537, line 29, page 538, lines 1 through 34 and 51, page 539, lines 13 to 37, page 540, lines 125 and 50, page 541, lines 30.
Mr. Carpenter, please. Senator Perullo, would you be amenable for me calling on you, given that the packet of amendments are missing, or would you like Mr. Carpenter to continue to read into the record?
For the sake of time, Mr. President, please dispense with reading. And
Senator Perullo is recognized.
thank you, Mr. President. Members, I want to come down here and talk about, let me move the amendment to the journal first.
To the amendment, to the Perullo amendment to the journal.
Thank you, members. This amendment does what similar members have, corrects a journal to say I was excused. I'll first explain my process. Thursday morning, 9 a.m., I asked the secretary if I should ask to be excused in the well. She suggested I speak with the majority leader. I spoke with him. He was busy. I spoke with him a second time. Then I went and spoke with Assistant Minority Leader Cook because Minority Leader Holbert was busy. And I apologize for assuming that between the three of them, word would get to the president. I understand the rules and I'll follow them. I want to talk about something that me and some of the older members of this chamber have been referring to lately and feeling. I came to the House in 2009, and things have drastically changed. And I can't just say it's us that have changed, but I think it's our culture that has changed. And why do I think our culture has changed? In part, based on a lot of studies and reading that I've done, it's a lot of these devices we have in our hands that we're always walking around with our face in. It's the social media, the 24-hour news cycle that started in the 80s, and now the 24-hour social media cycle that feeds on negative, that feeds on gotcha this, gotcha that. And so I ask not just this body, but the folks out there listening, try to limit your time. Try to be smart with what you focus on. Spend time with your families and your kids, and keep devices, as my wife and I learned with our oldest child, of which we have 4. Keep the devices away from them as long as possible. I am concerned about the direction of not only this state, but our country, because I think we're all losing the respect for that precious gift that our founders gave us. Respect of the process, respect of the rules, respect of the members, respect of the institution. So with that, I'll leave it at that for the sake of time so we can get back to the work for the people of the state of Colorado. I will explain where I was. I took my wife to a resort to enjoy a quick weekend away from our 4 children to celebrate our 23rd anniversary, and I booked the trip about 8 weeks ago. So we had fun. Unfortunately, my mind was back here with you guys a little more than she would have preferred, but that is the truth of the matter. And with that, I ask for an aye vote on the amendment and request a roll call vote.
The motion before the body is the Priola amendment to the journal. A roll call vote has been requested. Mr. Carpenter, please poll the senators.
Senators Bridges. Bridges, no. Cook. Cook, aye. Quorum. Quorum, aye. Court. Court, no. Crowder. Crowder, aye. Danielson. Danielson, no. Donovan. Donovan, no. Binberg. Binberg, no. Fields. Fields, no. Foote. Foote, aye. Gardner. Gardner, aye. Janal. Janal, no. Gonzalez. Gonzalez, no. Hill. Hill, aye. Heisey. Heisey, aye. Holbert. Holbert, aye. Lee. Lee, no. Lundeen. Lundeen, aye. Marble. Marble, aye. Moreno. Moreno, no. Pedersen. Pedersen, no. Priola. Priola, aye. Rankin. Rankin, aye. Rodriguez. Rodriguez, no. Scott. Scott, aye. Smallwood. Smallwood, aye. Sonnenberg. Sonnenberg, aye. Story. Story, no. Tate. Tate, aye. Todd. Todd, no. Williams, excused. Winter. Winter, aye. Woodward. Woodward, aye. Zinzinger. Zinzinger, no. Mr. President. No. Mr. President, no.
With 18 ayes, 16 no votes, 0 absent, 1 excused, that amendment is adopted. Approval of the journal. The underlying question before the body is the approval of the journal. All those in favor say aye. All those opposed, no. The ayes have it, and the journal is approved. Senate Services.
Correctly engrossed, Senate Bill 5 and 144, Senate Resolution 5 correctly re-engrossed, Senate Bill 2, 3, and 10 correctly revised, House Bill 1135, 1170, 1177 correctly revised, House Bill 1007, 1106, 1166, 1173, and 1209.
Message from the House.
House has passed on third reading and transmitted. The revised statutes, House Bill 1196, 1238. The House has passed on third reading and returns here with Senate Bill 31, also used for SCRs. The House has passed on third reading and returns with the revised statutes, Senate Bill 7688. Amended is printed in House Journal, March 22nd, 2019. In response to the request of the Senate, the Speaker has appointed Representatives Tipper, Chairman Hooten, and Larson as House conferees on the First Conference Committee on Senate Bill 106.
Message from the Reviser.
We herewith transmit without comment House Bill 1196, 1238 without comment as amended, Senate Bill 76 and 88.
Introduction of bills.
Senate Bill 207 by Senator Moreno and Representative Escar concerning the provision for the payment of the expenses of the executive, legislative, and judicial departments of the state of Colorado and of its agencies and institutions for and during the fiscal year beginning July 1st, 2019, except as otherwise noted.
Appropriations.
Senate Bill 208 by Senator Moreno and Representative Escar concerning a transfer of money from the State Employee Reserve Fund to the General Fund.
Appropriations.
Senate Bill 209 by Senator Zinzinger and Representative Hansen concerning provisions relating to PACE programs in connection therewith, determining the funding methodology for the 2019-20 fiscal year and fiscal years thereafter, requiring the Department of Healthcare Policy and Financing to meet with Colorado PACE programs during the 2019 legislative interim to consider PACE programs funding and other issues relating to PACE programs and making an appropriation.
Appropriations.
Senate Bill 210 by Senator Moreno and Representative Ransom concerning juvenile detention beds in connection therewith, reducing appropriations.
Appropriations.
Senate Bill 211 by Senator Moreno and Representative Escar concerning changes to the mental health criminal justice diversion programs in connection therewith, making an appropriation.
Appropriations.
Senate Bill 212 by Senator Rankin, Representative Escar concerning general fund support to implement the state water plan in connection therewith, making an appropriation.
Appropriations.
Senate Bill 213 by Senator Rankin, Representative Ransom concerning transfers from the marijuana cash fund to the marijuana tax cash fund.
Appropriations.
Senate Bill 214 by Senator Rankin and Representatives Escar and Ransom concerning capital-related transfers of money.
Appropriations.
Senate Bill 215 by Senator Rodriguez and Representative Valentine concerning the creation of the Parents Encouraging Parents Conference for Parents of Children with Disabilities.
Education.
Senate Bill 216 by Senator Bridges and Representative Berg concerning incentives for local education providers to provide innovative learning opportunities for high school students.
Education.
House Bill 1030 by Representatives Soper and Roberts and Senators Rankin and Zinzinger concerning creating the crime of unlawful electronic sexual communication.
Judiciary.
House Bill 1087 by Representatives Soper and Hanson, Senators Woodward and Bridges concerning online notice of public meetings of a local governmental entity.
Local government.
House Bill 1160 by Representatives Landgraf and Singer and Senator Gardner concerning a mental health facility pilot program in connection with making an appropriation.
State Veterans and Military Affairs.
House Bill 1194 by Representatives Valentine and Larson, Senators Priola and Fields concerning the discipline of preschool through second grade students enrolled in publicly funded education programs.
Education.
House Bill 1213 by Representative Tone and Senator Priola concerning the compensation payable to a member of a board of directors of urban drainage and flood control district.
Local government.
House Bill 1220 by Representative Sullivan and Senator Fields concerning allowing a court facility dog to accompany a witness during testimony.
Judiciary.
House Bill 1224 by Representative Hayard and Senator Winter concerning providing free menstrual hygiene products to people in custody.
Judiciary. Third reading of bills. Consent calendar. Mr. Carpenter, please read the titles of the bill on the third reading consent calendar.
Senate Bill 144 by Senator Zinzinger and Representative Roberts concerning allowing a driver of a motorcycle to proceed past a malfunctioning traffic control signal.
Mr. Majority Leader.
Thank you, Mr. President. I move the passage of the bill on the third reading of bill's consent calendar, which includes Senate Bill 144.
Is there any discussion on the bill on the third reading consent calendar? Are there any no votes on the third reading consent calendar bill? Senate Bill 144. With a vote of 34 ayes, 0 noes, 0 absent, and 1 excuse, Senate Bill 144 is passed. Co-sponsors: Senators Sonnenberg, Crowder, Hill, Heisey, Cook, Todd, Bridges, Minority Leader, Marble, Lundeen, Smallwood, Rankin, Woodward, Gardner, Tate, Scott. Third reading of bills, final passage. Mr. Carpenter, please read the title to House Bill 1129.
House Bill 1129 by Representatives Michelson, Janae, and Escar and Senator Finberg concerning prohibiting a mental health care provider from engaging in conversion therapy with a patient under 18 years of age.
Mr. Majority Leader.
Thank you, Mr. President. I move House Bill 1129 on third reading and final passage.
Is there further discussion on House Bill 1129? Senator Hill.
Thank you, Mr. President. Colleagues, I appreciate the chance to actually discuss a bill. I am respectfully opposed to 1129, have been for some years. We certainly have some barbaric practices that go on that I get is the intent we're trying to control here. I am worried and concerned that in the process of that, we are going too far. We are infringing upon not just First Amendment rights, but also the opportunity of someone to pursue the counseling services that they desire. And I am, you all know my rather libertarian tendencies up here. I think we need to trust our citizens more. I think we have actually associations that can control this and address these practices in a much better way than we can as a legislature. I think we have we have set a difficult precedence that the legislature can determine what conversations you can and can't have. So with that, Mr. President, I respectfully ask for a no vote on 1129.
Further discussion? Seeing none, the motion before the body is the passage of House Bill 1129 on third reading and final passage. Are there any no votes? Senators Sonnenberg, Heisey, Marble, Woodward, Rankin, Lundin, Crowder, Cook, Hill, Minority Leader, Smallwood, Gardner, Scott. With a vote of 21 ayes, 13 noes, 0 absent, 1 excused, House Bill 1129 is passed. Co-sponsors: Senators Donovan, Danielson, Rodriguez, Janal, Story, Winter, Fields, Patterson, Court, Gonzalez, Bridges, Foote, Zenzinger. Mr. Carpenter, please read the title to Senate Bill 005. Excuse me, Mr. Carpenter, please read the title to House Bill 1177.
House Bill 1177 by Representatives Sullivan and Garnett, Senators Cord and Pedersen, concerning creation of extreme risk protection order in connection therewith, making an appropriation.
Mr. Majority Leader.
Thank you, Mr. President. I move House Bill 1177 lay over until tomorrow, Tuesday, March 26th.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and House Bill 1177 will lay it over until Tuesday, the 26th, under the rules. Mr. Carpenter, please read the title to Senate Bill 005.
Senate Bill 5 by Senators Rodriguez and Janal and Representative Hawkins Lewis concerning wholesale importation of prescription pharmaceutical products from Canada for resale to Colorado residents in connection therewith, making an appropriation.
Senator Rodriguez.
Thank you, Mr. President. I move passage of Senate Bill 5 on third reading and final passage.
Is there further discussion? Senator Smallwood.
Thank you, Mr. President. Appreciate the sponsors bringing this forward. You know, this is an interesting bill. We've heard support about this bill from literally every party every year for the last several. I'm going to be a no vote on Senate Bill 5 today, and not even because I hate the idea. If it was something that I thought would work, it's certainly popular. I want to say something like 70% of Americans think that it's a great idea. Candidly, colleagues, I just don't think it'll work. I think two things are going to happen. First of all, I think the federal government is not going to allow us to do this as a state, which, if there was no fiscal note attached, no problem. Why don't we just ask and find out? Secondly, I don't think pharmaceutical companies are as stupid as some of us might think that they are. You know, there's less than 50 million Canadians, I believe, 30, 40 million Canadians, smaller than many of our areas of the country here. If I kind of wonder how it's going to look if you're a pharmaceutical company and you're shipping medication to a country expecting to have a certain number of prescriptions filled, and all of a sudden the volume in that deal that you made with that country, all of a sudden you see the volume of prescriptions increase by, if only Colorado signs on board, 15%. If California comes on board, over doubling. Let's say the whole country, we decide we're going to do this. So now we see, 360 million new Canadian prescribers of medications. Do we really think that the pharmaceutical companies are going to do nothing? That they're just simply going to look back and go, wow, I guess we made a bad deal negotiating with Canada. This is really going to hurt our bottom line this year. Or, colleagues, are those drug companies maybe going to consider changing the prices that they charge Canada? There's a reason why medications or any product are sold at different prices globally. And to think that we can somehow do an end around on this and gimmick the system, Candidly, I'm just skeptical more than anything else. Last year, we ran a bill that required the federal government's approval just to allow us to sell catastrophic individual health insurance plans. That was a bipartisan, bicameral bill that I was on. And I felt guilty because it cost several $1,000s for us to commission the study to see if the federal government would approve this. And guess what happened? The federal government told our DOI, no, it's not going to happen. Wasted money. And that was a few $1,000s. Now, what we're talking about in this bill, if I understand the fiscal note correctly, and the sponsors or anybody else can certainly come and correct me, we're talking about millions of dollars. So those that are on JBC have talked to me about the fact that projections are smaller than they're supposed to be. And as a state, we might not have the money in the general fund that we originally thought we might have. And yet we're willing to bet millions of dollars on an experiment that may or may not get approval from the federal government. So you might ask, well, what are our alternatives? Why wouldn't you support at least trying? And my answer is, well, Vermont already passed this. So we don't need to wonder whether or not there's a good chance that the federal government approves this. All we have to do is wait. Hold on to our millions of dollars and wait for a short period of time to see what happens in Vermont. And if Vermont's program gets approved, then I could see supporting this. Right? We already know that it's going to work. I think it's short-lived. I think we'll see prescription drug savings maybe for a year or two. But if pharmaceutical companies are, as I don't want to use the term stupid, asleep at the wheel maybe, like we think that they might be, that they're not tracking their global pricing, then our citizens get to take advantage of this. The other thing with this bill that we have to remember, colleagues, as we heard in committee, many of you might think, when I say you, the collective you, might think that what we're doing with this bill is saving money for our most vulnerable population, like those on Medicaid, those on Medicare. Well, we asked that question in committee, who does this benefit? Does this benefit people on Medicaid? And Healthcare Policy and Financing said no. People on Medicaid won't be able to take advantage. And if I understood them correctly, people on Medicare also wouldn't be able to take advantage of this program. This program, like Vermont's, only benefits commercial insurers, not people on Medicaid, not people on Medicare. And remember, if you make too much money to be on Medicaid, you've purchased an exchange policy in our state up to 250% of federal poverty level, you're also getting cost-sharing reductions for your prescription drugs that dramatically lower the cost already. So I would have liked to have seen a number of amendments in this, but it sounds like those were all rejected. I was disappointed to hear that even an amendment that would ensure that Coloradans are receiving safe drugs was rejected on the floor on Friday. But what, again, I would encourage the sponsors to consider is, can't we just hang on to our millions of precious taxpayer dollars to see what happens in the Vermont decision before we plow forward in a program that has never been approved in any other city or any other state? Do we really think that this is a good use of taxpayer funds? I would say no. So I urge a no vote on Senate Bill 5 unamended. Thank you.
Is there further discussion? Senator Hill.
Thank you, Mr. President. Colleagues, there's a form I could support this bill in. There's a concept here I think that is all too missing right now in American economics, and that's the idea of free trade, both the appropriate and free flow of capital as well as labor. For a long time, my understanding is that was a pillar of the Republican Party. And so perhaps, Mr. President, if the rules permitted, I would offer a conceptual amendment to fix this bill. I have a feeling that's not in order. What could fix this bill is if we said, as Colorado has done before, it's a technical term in politics, but to give the middle finger to the FDA and the federal government and say, Colorado's going to do things our way. And we've done that, and I would argue that was the right thing to do with certain controlled substances. We could do that here. We could tell the FDA, you're not welcome in Colorado, we're going to do things our own way. One of the challenges we have with the FDA that I think every single person in this room would say is that the FDA and Big Pharma have far too much in common on how many of these decisions are made. And I would say consumers are hurt by that. The problem is, that's not what this bill does. Our bill doesn't say we're going to trust Colorado consumers to make these decisions and get government out of the way. In fact, what this says is we're going to take money from the people, we're going to take millions of dollars, and we're going to ask government to do a government study to petition the other government to see if government can solve this problem. Friends, government is the problem in the prescription drug challenges we face right now, and no amount of further government meddling in this, I would posit, would solve it. We could solve it if we were serious. I think we could solve it in a bipartisan way. Sadly, I don't think spending millions of dollars that could be going to roads, that could be going to paying our teachers on something when we all know the outcome of this, just to get a talking point that I think feels good. I think it's right. I don't think it's the right way to do it when there's a way we could actually do this that I think a majority of Coloradans would truly be behind. I ask for your no vote on Senate Bill 5.
Senator Crowder.
Thank you, Mr. President. I did hear this in committee also, and I did support it. And I'm going to be a yes vote on this bill. And I think my colleagues who just spoke are all absolutely correct in what they're saying. But I think we've got a long ways to go on this. I think we have an opportunity here with modern day technology to make innovations on this that would actually reduce the drug prices of the people of the state, in this state as well as this country. I think it's time we need to move in a direction of we're kind of going into the unknown on a lot of this technology and whatnot, and we're definitely going into the unknown whether or not the waiver is accepted by the federal government. But I think if you have medications and drugs that are 5 times cheaper coming out of Canada, which actually are manufactured in the United States, I think there's merit to this, and I think this has several ways to go. By the time it gets to the House or through the committees in the House, I think there'll be a lot of innovative changes on this as far as amendments. But I do believe that there is merit to this, and I think we need to actually to take advantage of how we can decrease the cost of drugs for the people. And I had planned on having an amendment now, but after talking to both sponsors, they both rejected the idea. So I think what we'll do is we'll pick it up in the House and see if we can't make the changes we think are necessary there to make this more workable. But I do believe that if more states come on board, we shouldn't have to wait for Connecticut or Vermont or whatever state it was. But I think the movement in what we need to do in the future for medications such as this should be more unified throughout the country. But I will, at this point in time, I will be a yes vote. Thank you.
Members, just a gentle reminder that the senatorial custom is that if you wish to speak, that you should be down in the well area. I will be noticing if members are staying, but please, if you will consult with the majority leader or the minority leader so that from afar I don't recognize someone, but if you can make your way down to the well area so that I can call on you accordingly. Senator Tate.
Thank you, Mr. President. I want to echo the concerns of my colleague from Parker. General concerns about general economic concerns and observations that arbitrage will ultimately whittle away the short-term benefits of this bill. Also, if you remember, I ran an amendment on second reading related to protecting Colorado consumers from trans-shipped products. I'm not going to beleaguer the body into the particulars of that, But I think it's just important to, as for me, it was important to have that protection, considering the overall effort to, quote, make this work, as my colleague from Parker mentioned, in my mind, will put pressure on the transship product issue. So again, I encourage a no vote on the bill. Thank you.
Senator Lundin.
Thank you very much, Mr. President. Members, thanks for your attention. I have two arguments against this bill. The first argument I would describe as the water always seeks its own level argument. It's the idea that it seems like a good idea, seems like a great idea, but as this begins to roll out, as it begins to happen, we're going to discover what was hoped to be saved, what was hoped to be passed along to the people in terms of savings on prescriptions will be a chimera. It will disappear. In fact, it won't necessarily happen. The second argument I would make in opposition to this bill could have been remedied. In our debate and discussion on seconds, there was an amendment offered by the good senator from Aurora that would have sought to address this issue of product safety. And quite frankly, when we're talking about the pharmaceuticals that we put into our bodies and we put into the bodies of our children and grandchildren, safety is really important. And the amendment simply would have said, even though the bill does say, fit for human consumption essentially, it simply says know what you're actually getting. The amendment said specifically each prescription pharmaceutical product that the supplier exports to the program for dispensation, dispensation, that sounds like a theological term quite frankly, but it is appropriate here, to Colorado residents is manufactured for consumption by Canadian residents and not diverted or otherwise sourced from any other market. And this is very important. This is meaningful that the idea was it was a product that the citizens of Canada knew they had received it. It had been sourced specifically for them. It's not something that was being diverted from another market. Now, there's a lot of knockoffs that come into our economy. There's knockoffs on Louis Vuitton purses. But if you buy a Louis Vuitton purse that's not a Louis Vuitton purse, you're gonna survive. Probably not a big deal. There's knockoffs on all sorts of things throughout the economy. But a knockoff on a pharmaceutical that you're going to put into your child's system or your grandchild's system or your own system, not acceptable. This amendment, had it been accepted, would in fact have alleviated major elements of that concern. So based on these two arguments, a product safety question that still lingers with this bill as currently brought to us on third reading today, and the idea that what we think we're going to get is going to evaporate before our eyes under the forces of market forces, are two, I think, sound reasons for an objection to and a vote against this bill. Thank you, Mr. President.
Senator Janal.
Thank you, Mr. President. And I rise in strong support of Senate Bill 005, and I think there's been a lot of misconceptions out there. First of all, the fact that the federal government doesn't allow this, so why should we try until they start? Well, why shouldn't we try? Because no one else has come up with a better answer at this point, and it's innovative, it's state administered, and it is an importation program, but it isn't of every single drug that's out there, and I think that's where some of the misunderstanding is. It's not about generic drugs, it's not about biologics, it's not about drugs that are opioids or narcotics. It's about some of the most expensive prescription brand name drugs that are out in the market that people really need. And it doesn't matter if they're in a private insurance, if they're paying for their own, or however they're paying for these drugs. I think one of the misconceptions is that it's all drugs when it could be 6, it could be 12, it could be 20 drugs. These are the drugs that are going to be the most cost savings to the people of Colorado. And they're not illicit drugs, they're not unsafe drugs, because most of them are made in the United States or in conjunction with a United States pharmaceutical company made in Canada. And we're buying them back from Canada. You know, we talk about this as being a bipartisan bill, and it really is if you look at the other states that are involved here. Colorado happens to be one state, but there are more than 6 other states that are going forth with a similar type of bill. And Florida, for example, is Republican-led. Utah, West Virginia, Oklahoma. In fact, we use Vermont, who has only used 16 drugs on their formulary, and asked for those. And that's what we're using as an example. But when you look at it, there's a lot of these types of bills that are being brought forth that are led by Republicans. So I wanted to clear that up. The other point is that this is a program where the state is going to take on the responsibility to act as a wholesale importer. And in order to get that federal certification, all we have to do is 2 things, according to the federal Secretary of Health and Human Services. That is, that we need to pose no additional risk to the public's health and safety. And I guarantee you, with all the things that are in place, that's not going to happen. And there's a track and trace. And also, the result has to have a significant price reduction to the United States consumer and the United States patient. And if HICPUF can't put that program together and send it to the federal government, to Health and Human Services, which I have the utmost confidence that they will. If it gets rejected, it gets rejected. That's not up to the state of Colorado. That's up to the federal government. And again, we're not the only state doing this. The last thing I want to clarify is I'm hearing millions and millions of dollars we're putting into this. And I look at the fiscal note. Yes, it is $1 million, $1.3 million to set up this program that will be timely. I know Friday was kind of a crazy day for all of us, but I think you remember that I introduced the children and the families of hemophiliacs and people who had various rare blood disorders. And if you put this into perspective of the 2019-2020 fiscal year at $1.3 million to put this program together, if you had talked to those children and their families, there's a drug that they need for a life-giving drug for hemophilia, and it's $300,000 to $600,000 per year for those children and those young adults to stay alive. Now, if I do my math correctly, at $1.3 million, 2.5 to 3 people with hemophilia would get a year's treatment from $1.3 million. And some of these other brands that are out on the market now are probably even more than that. So what I'm trying to say is that this $1.3 million may sound like a lot of money to all of us, but when you compare it to the price that someone has to pay for a brand name drug and might be able to get it for a third, 2/3 of that cost, this doesn't sound like a whole lot to try to make a plan to save money for people. I'm here to help the patients, and I don't care what side of the aisle you're on. And if it saves lives, and if this plan works, and it looks like it's going to work in some other states that are not democratically led states, I ask for your support for this bill. Thank you.
Seeing no further discussion, the question before the body is the passage of Senate Bill 005 on third reading and final passage. Are there any no votes? Senators Sonnenberg, Heisey, Marble, Hill, Cook, Lundin, Gardner, Woodward, Tate, Smallwood, Rankin, Priola, the Minority Leader, Scott. With a vote of 20 ayes, 14 noes, 0 absent, and 1 excused, Senate Bill 005 is passed. Co-sponsors, Senators Donovan, Bridges, Gonzalez, Lee, Pedersen, Danielson, Fields, Foote. Please add the president. Story. Todd. Senator Crowder. Mr. Carpenter, please read the title to House Bill 1135.
House Bill 1135 by Representative Gray and Senators Tate and Winter concerning clarification that the income tax credit for retrofitting residents to increase their residence accessibility is available for changes made to residents that benefit qualified individuals dependent.
Senator Winter.
Thank you, Mr. President. I move House Bill 1135 for third reading and final passage.
Is there further discussion? Senator Tate.
Thank you, Mr. President. Members, just to kind of provide a little context, this bill is kind of a clarification bill from a bill I ran last year, in that we created the tax credit, but we forgot to include dependents as a subject for whom these home modifications would be made. And so I urge an aye vote. Thank you.
Is there further discussion on House Bill 1135? Seeing none, the motion before the body is the passage of House Bill 1135 on third reading and final passage. Are there any no votes? Senators Lundin, Sonnenberg, Woodward, Marble, Scott, Cook, the Minority Leader. With a vote of 27 ayes, 7 no votes, 0 absent, 1 excused, House Bill 1135 is passed. Co-sponsors, Senators Bridges, Story, Janal, Crowder, Hill, Lee, Todd, Senzinger, Pedersen. Please add the president. Mr. Carpenter, please read the title to House Bill 1177. Excuse me, House Bill 1170.
House Bill 1170 by Representative Jackson, Westminster, Williams, and Bridges concerning increasing tenant protections related to the residential warranty of habitability.
Mr. Majority Leader.
Thank you, Mr. President. I move House Bill 1170 lay over until tomorrow, Tuesday, March 26th.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the motion is adopted. House Bill 1170 will be laid over until Tuesday, the 26th, under the rules. Mr. Majority Leader.
Thank you, Mr. President. Members, I'm going to make a motion to recess until 4 p.m. We will be breaking for committee right now, so we might not actually be coming back at 4, but it'll be 4 at the earliest. But listen for a call. We will probably do a call about 15 minutes or so after the last committee is done. Mr. President, with that, I move the Senate stand in recess until 4 p.m. today.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the motion is adopted. The Senate will stand in recess until 1600 today.